Okay. Okay. All right. Just wanted to housekeeping matters. We're live streaming at fcc.gov/live. In approximately 2-3 days, the video will be up, captioned. Anybody who has questions who are watching on the live stream can send them in to livequestions@fcc.gov. Those in the room who have questions, we have staff here with index cards. Just raise your hand and we'll collect the cards and we'll read them here. If you have a phone, could you please turn it off? Thank you. Lunch will be from 12 to 1. Kind of a tight schedule, so try to get back at 1. And we have a list of restaurants. We have programs at the table as you come in. And now, to keep us on schedule, and with no further ado, the chairman of the FCC, Tom Wheeler.
Thank you, Roger. Welcome to everybody, and particularly welcome to those who are watching online, who I know includes Commissioner O'Reilly, who we'll have a letter from him read into the record in a moment. But part of that letter to me states that he will be watching online, but he has to be on the road today. So, Mike, good morning, and we're glad you're here too. But I want to thank all of the participants in today's session and the staff that worked so hard to pull it together. I was, riding down the elevator today. There was a discussion. Wow, you got him. That's a great, catch. And so there's a terrific lineup of people. I also want to specifically call out our federal colleagues, Chris Olson of the FTC and John Verdi of NTIA. Thank you very much for joining us. The issue that we deal with today falls under a broader construct, which is basically the concept that changes in technology don't change our values. And how we deal with that is what makes this era so challenging, what makes the job at this commission so exciting. But we need to know that we don't need to remember, we've all dealt with these issues before in society. I've just finished reading that fabulous Ron Chernow book on Alexander Hamilton, and was taken by the fact that the founding fathers, as they're sending letters back to each other, doing such things as formatting what becomes the Federalist Papers, are worried about their mail being intercepted and the other side seeing what they're thinking and what they're about to do. I wrote a book on the telegraph, and it talks in there about how telegraph messages had to be ciphered during the Civil War because they were being intercepted. Now, the interesting thing, and I'll digress here a second, but what we're talking about today is a little different from Mosby's raiders, who would shimmy up a telegraph pole, cut the cable, cut the wire, and then hold it to their tongue so that the electric pulse would react with the saliva on their tongue, and they would get little shocks, and that would allow them to intercept the message. I think what we're talking about today is a little beyond that technologically, but these have always been challenges. They were challenges that we faced in the telephone era, as you know so well. But now we're in an era where the network and the information that it carries are increasingly synonymous. And we're in an era where information is the capital asset of the 21st century. Congress was very explicit in their instructions to us that consumers have the right to expect privacy of the information that networks collect about them. Yet in a digital world, every time we use a network, we leave digital footprints all over the place. How do we deal with that? Privacy is unassailable. And the virtuous circle of innovation, begetting infrastructure, begetting further innovation, going on and on, is essential. So today, at this session, I hope that our goal can be to answer the question, one, how do we make sure that Section 222 continues to protect consumers? And two, how do we promote the virtuous circle of innovation and investment? This is the beginning of a very important discussion. We're grateful to all of you for being here, and I look forward to what we're about to hear. So thank you very much.
Thank you, Mr. Chairman. I'm Matt Del Nero with the Wireline Bureau. As the chairman mentioned, Commissioner O'Reilly is away from Washington on travel today, but has provided a statement that he asked us to read, and I will say for which we are, as staff, we are grateful for his statement and his participation online. He states, respectfully, I request you to extend to all attendees my heartfelt apology for being unable to attend and participate in the Commission's public workshop on broadband consumer privacy, having spent considerable time in my career examining different privacy provisions in law, including that relevant to the Commission, and working on numerous legislative efforts related to the privacy of consumers. I am disappointed that prior commitments keep me out of town and from exploring this topic in fulsome detail at this event. Please do know that I will watch today's proceedings online and will be actively involved in any effort by the Commission in this area. So thank you again to Commissioner O'Reilly. I would note before introducing Professor Blaze, who will be our first speaker, in terms of the sequencing events, there is some confusion between our printed handouts here and the actual schedule, so apologies for that. We'll be hearing from Professor Blaze from 10:15 to 10:45. The first panel, which is on privacy implications associated with broadband internet access service, will be from 10:45 to noon. We'll break from noon to 1, and promptly at 1 we'll begin the second panel, which is on the application of Section 222 of the Communications Act to broadband internet access services. That will go from 1 to 2:15, at which point we'll conclude. So with that, I'd like to introduce Professor Blaze, who we're very fortunate to have here to provide an overview of the use and collection of broadband subscriber data. You have his bio. That part is correct in the printed material. He's Associate Professor of Computer and Information Science at the University of Pennsylvania School of Engineering and Applied Science. And thank you again, Professor Blaze, for joining us.
Thank you. So I want to start with an apology. I am absolutely not a telecommunications lawyer. And had I thought that I was, the term declining forbearance would have absolutely established that fact. I have to admit, I spent about half of the time that I spent preparing for this trying to figure out what that meant. So I have learned something as a result of this. So I have a few slides that I prepared, which are just going to be an outline of what I'm going to talk about. But I think I want to approach this from sort of technical first principles of just what is an internet service provider and what does it mean to have internet services, and why internet services may be what we're buying, but it may not quite be what we're getting. And in particular, I'll talk about the concept of making networks smart and how that conflicts with our understanding of internet service from a technological point of view, and how that results in data being collected that we might not expect to be collected and that might not have to be collected if we look at the network a little bit differently. And then I'll talk a little bit about how we can think about protecting that data and what data should be protected, and whether technical measures or policy and legal measures are the right approach for doing this. And okay, so internet service provider is a term that we've abbreviated into ISPs. I think we've kind of forgotten what it stands for. We all have internet service, and we think we get it from an internet service provider, but I'm not actually sure that that's true. Almost nobody claims to be an internet service provider. We've kind of replaced that term with broadband provider or a wireless provider or something a little bit different. And part of the reason for that is that what we're getting is actually a little bit different. As a technologist, I understand internet service in a very pure and beautiful way. We have this idea of a protocol stack that goes down from the physical layer, the wires or wireless media over which signals get transmitted in analog form. They get converted up this protocol stack into some kind of a digital form, and then eventually they reach the application and the user. And we sometimes talk about it having another layer on top called the religious layer that basically says that this protocol stack is really the way we think about networking. And it's been a very powerful technical idea. It's what led us to the idea that the network might not be where we want the intelligence. And it led us to this idea that we can build more powerful applications on top of a network that hasn't actually been built for supporting a specific application. And we often describe the protocol stack as sort of an hourglass, where you have many, many things down at the physical layer, and they become a little narrower into a data link layer, and then they narrow down more at this layer called layer 3, or the network layer, whose job is simply to deliver datagrams to the destination listed in them, and nothing else. And then we expand that out when it reaches its destination into ultimately the applications. And this idea, I will have to say, technologists really are fond of this. This is, and as a technologist, I share this fondness, and I feel defensive toward it, because what it has led to is a network that didn't have to know what was being done with it. Its job is simple. Building a router is a device you can buy at Radio Shack, if there's still Radio Shack, or Best Buy or wherever, and it performs essentially an equivalent function to what a phone switch did in circuit switch networks, except that instead of occupying an entire building and costing millions of dollars, it's thrown in free with your service. The equipment that makes up the inside of the network is ultimately not all that different from the routing equipment that we have at home. So this idea is an extremely powerful one, and one of the things that we should do is be very skeptical of anything that threatens that model. And one of the sometimes there may be reasons to, but we should approach them with skepticism. The extraordinary claims require extraordinary evidence. Very much applies here. Now, what you actually get from an internet service provider is not just layer 3. And in practice, they throw in some other things that add additional services but don't really change the fundamental model. For example, you often get domain name service along with your internet service, and that's something that goes outside of that protocol stack. And usually, internet service providers will throw in things like email accounts and email services, which are really application services, but those are just sort of added on and bundled in and not very expensive to provide, and they don't really affect this idea that the network really only has to look at the destination where individual packets are going. It doesn't have to keep any state about where they've come from, and its job is fundamentally to get things on its way as quickly and as efficiently as possible. So where that's left us is that we're starting to see a desire, and we've been seeing this, I think, over the course of the last 2 decades when consumer and small business networking services started to emerge, of networks that want to be a little more than that. In some sense, calling the internet, moving the intelligence outside of the network is a little bit discomforting to those who are providing the network itself. And so there's a desire to think about, well, maybe we want a smart network. Maybe we want to be able to look deeper into the data and do smart things with that of one sort or another. And that leads to the things like deep packet inspection, where we look beyond just the destination of data and make decisions and perhaps keep track of things in ways that aren't required in the classic model. And one question is just how deeply might we look, and what might that mean from a privacy perspective? All right. So, what in the model of kind of standard internet, we think of there's some terms that get used. One of the important terms is statelessness, that the network doesn't have to keep track in principle of anything other than the packets that are immediately before it, and just deliver them more quickly to their destination. And this comes alongside the idea that the network is not connection-oriented, but connection-less, and has a job of just switching packets to their destination. And an effect of this from an economic point of view is that this ultimately, in an ideal world, turns network providers into essentially a commodity. If you can deliver your packets to their destination more quickly than and perhaps more reliably than the competition, you're doing better, and that's really the only metric that one needs to look at to understand what you're getting from it. So we're basically able to measure network performance and the quality of service that you're getting along very, very few dimensions, and that has the effect of turning internet services in this ideal world into a commodity, and I think nobody wants to be a commodity. I presume that many of the people in this room work for internet service providers and are very frightened of the idea of turning into a commodity business with very low profit margins and fewer opportunities to take the core services and monetize them in different ways and so on. So we have a tendency for ISPs to try to become smarter. In other words, to try to turn themselves back into the types of networks that we had in the old telephone era. So one of the problems, or one of the policy challenges, is that there's nothing wrong with internet providers trying to be innovative, and that's certainly a good thing. But smart can also mean intrusive. And it can lead to things like deep packet inspection that breaks the layering model. In other words, it can lead us to a situation in which the network does have to be optimized for particular applications, which has the effect of making it unoptimized for other applications. It means that we suddenly have to get the cooperation of the network itself if we want to build new and innovative services. Now, this is largely something we talked about in the context of things like network neutrality, but it also has to do with privacy, because the more the network is doing with the data that's beyond what it needs to do its job of routing packets, the more information gets collected and the more state information the network maintains about how its users are using it, what their behavior is, and private information that they may not understand is being shared. We have things like DNS, domain name services, that are integrated with search. We have things like cookie injection into web traffic. Web traffic is an application layer service, yet somehow internet service providers often act as an perhaps unwanted intermediary and inject tracking cookies to monitor and link user behavior from one session through another. We have discussion of partnerships with other organizations. Partnerships has become almost entirely a euphemism for advertising networks and the availability of advertising services within the network itself. So there the customer becomes not just the customer, but the product as well. And again, these all have privacy implications, because the more information you have about the product, the customers, the higher a price it can fetch to advertisers. All right, so smarter basically means more data. And more state in the network means more data that is being logged. So we have things like persistent identifiers for users, sometimes injected deeply into the network itself. We have information that gets logged about sessions. We often refer to network flows as being something that gets logged. From a technical point of view, that makes sense, because for network management, that's useful to do. There's nothing nefarious about understanding that there is some state and that a user is connecting to a particular place, and maybe that you can make network management decisions based on that. But it also means that now, rather than simply delivering packets from one end to another, there's a higher level view of what you're doing and of what's going on with your sessions, and logging that information is effectively free. It goes down with the cost of storage. The cost of storage is vanishingly small when you have network equipment that's able to identify flows as they're going by. That information becomes feasible to keep track of on the fly for everyone and to store essentially forever. The general principle the general principle is to keep data forever. There's no reason not to, and it might be useful someday. If you are collecting data you might use it immediately. You might also understand that you might want to use it in the future, and nobody ever throws away data unless they absolutely have to. And as a technologist, I would say yes, keep it. Oh, thank you. As a technologist, that's a sensible decision. But what it also means is that this kind of data gets repurposed after it's collected. Data that was collected years ago, we find new uses for, and it gets monetized and shared with partners, and privacy policies that seemed inscrutable allow that to be shared in ways that the people whose data was logged may not have understood at the time that it was collected, and may not have had any meaningful way to opt out of or opt into. So, these sound technical decisions that we're making also have risks associated with them that we have to keep a careful eye on if we don't want unexpected consequences and unexpected privacy violations. All right, so one of the difficult distinctions from a technical point of view is the distinction between content, which is generally not stored by network providers, and generally has the strongest legal protections associated with it, and metadata about the content. So we draw this distinction both technically and legally from a policy point of view between the content of communications, which is largely regarded as somewhat sacred, and the information about it, the information that's been collected in routine network use in the ordinary course of business that we sometimes call the metadata. Unfortunately, as we increase the amount of data and the pace of communication and the number of different things we communicate with, the line between what we consider content and what we consider information about that content and less sensitive becomes extremely blurry, and the line is pushing toward more and more of what we meaningfully communicate with each other really starts to look a lot more like the metadata than the content itself. Things like your location information, and this is a significant issue in mobile networks, but also even in wireline networks as you might move around from place to place. Your communities of interest, which is really a euphemism for who you communicate with, who your friends are, what is your real social and personal network. The tracking cookies that may be injected into your web sessions, the logs of what you're connected to when you log in, what websites you reach, which we think of as being end-to-end services, but in fact, the more the smarter the network, the more likely it is that it's collecting this sort of metadata and treating it not as content, but as simply customer information. And as we become more and more, as we get more and more of the competition that we seek in broadband services, the pressure on internet service providers and broadband providers to monetize this data in some way goes up and up and up, and it can be done after the fact. We have most of the laws and policies concerning this draw this distinction between content and metadata. And, even outside of the context of the FCC, we have things like the third-party doctrine and Title III with the wiretap laws that really give great protection to content, but often give relatively short shrift to the privacy implications of the metadata. And technically, that line, the trend in technology is that line is going to push us toward more and more of our what we might think of as content. The network itself might think of as metadata. A sort of extreme example of that is there's an app for smartphones called Yo, whose entire function is to send the message Yo. That's the only message you can send. It's a 0-bit message, but you find out who it came from. And people use that to get one another's attention. The entire content of that message is the identity of who sent it to you and the time it got sent. And from a traditional communications model, that information is just metadata. It's not actually content at all, even though that's what really the content is. All right, so one question, and this is my interest as a technologist. I'm a cryptographer and computer security specialist. And one of the questions is, well, if consumers and users are concerned with this, perhaps we could have an environment in which we say, well, the network provider is free to just do whatever it wants. Logger's going to log. Let them do it, but let's just take countermeasures at the consumer end to prevent that data from being available in the first place. So we know how to do this pretty well for content. Things like encryption technology can take certain parts of our communications content under certain circumstances and make it unusable to anybody except the person they're communicating with. Now, some content data can't be effectively encrypted, and there's some difficulties with this, but the focus of almost all of the scientific and technical work on protecting data in insecure networks, in what may be adversarial, hostile environments, is focused on how to protect content. And the technology that we have to do it which is almost entirely based on encryption, is very good if used properly at protecting quite a bit of content. But metadata is something we know almost nothing about how to protect. This is an area of open research in which we've made remarkably little progress. This is sometimes called the traffic analysis problem, and most of what we know about it is that it is extremely hard to solve. And in practice, it's even harder to solve than it is in theory. There's some data that simply has to be exposed to the network. The network has to know, for example, where you're sending your information to in order to get it to its destination. It probably needs to know who you are in order to authenticate you to the network, and it is often collecting side information about you, such as where your DNS queries, what names you are looking up, as an adjunct to setting up your communication in the first place, and that becomes tantamount to to logging who you're communicating with. We have systems like Tor, the onion routing technique, which can be used to anonymize certain types of network connections, but really these are not general solutions. One question would be, well, how much of the internet's bandwidth do we want to devote to protecting metadata? Tor basically increases the amount of network traffic being consumed overall by a factor of 3. It's very expensive from a networking point of view, and it doesn't work well for all types of communication. It works very well for web browsing and certain other types of network sessions, but not so well for other things. So largely, no matter how tech savvy and no matter how much of the emerging technology that people like me are trying to produce, the consumer is basically left with no meaningful technical choices about protecting this. Technical protection is largely not an option unilaterally applied by the end user. We could say, well, if you were concerned about this data, you could encrypt it. You didn't need to send it. But in the case of metadata, that's really not a meaningful response. So this is from my point of view as a technologist, a little bit of a white flag of surrender to the policy people. My instinct is to say, well, if you only would let us technologists run things, we could build something really, really wonderful and really privacy protecting. And I have to admit that I think, for anybody at a funding agency, I think you should certainly fund academia and computer security to study this problem quite a bit. So if there's anyone from NSF in the room, please fund us to do this, because we're on the cusp of making great progress. But until we do, we really have to look to policy and regulation to address these problems, because there are really fundamental ways in which our data is exposed and is likely to be exposed for well, I won't say forever, but for the immediate future. So I think I left a few minutes for you to ask questions and establish again that I am not a telecommunications lawyer. So, thank you. Thank you.
Will panel one please come up? Thank you.
Good morning, everyone. Thank you for joining us. I'm Lisa Hone with the Wireline Competition Bureau here at the FCC, and I'm pleased to be joined by my co-moderator, Chris Olson, who is the Deputy Director of the Bureau of Consumer Protection at the Federal Trade Commission. So we have a lot to cover in this panel, and Professor Blaze, thanks for giving over a little of your time. I am not going to introduce every panelist with their full bios. You should have them in front of you, and these are an impressive group of panelists. Instead, what I'm going to do is introduce you to them in the order in which they will speak. Each of them is going to take 3 to 5 minutes to give an overview of key points that they think need to be part of the discussion as we start talking about the privacy implications of broadband providers. And then we will have a question and answer session. Now, I am not used to being in the position where the chairman of my agency is sitting behind me. So everyone over here, if he looks happy, give me a little thumbs up. If he doesn't look so happy, thank you, Gigi. Give me a little thumbs down so I can. Yeah. Thank you, Mr. Chairman. Again, I'm going to do a brief introduction for everybody, in the order in which they're going to speak. So Bob Quinn, Senior Vice President and Chief Privacy Officer of AT&T, is going to kick it off for us, followed by Josh Seidemann, Vice President at NTCA. And they're going to sort of set the stage for broadband providers, understanding that not all broadband providers have the same approach here, but this is the beginning of this conversation, and they're kind enough to set the stage. Then Laura Moy, Senior Policy Counsel at New America, and Michelle Lucan, an Assistant Attorney General from the Connecticut Attorney General's Office. We'll talk about this a little bit from the consumer perspective, followed by Catherine Tucker. I feel like I'm going in and out, but followed by Catherine Tucker, a professor at MIT, and John Verdi, Director of Privacy Initiatives at NTIA, who will, I think, circle around on how broadband privacy issues play in the broader ecosystem and lessons we've already learned in the privacy world. Does that make sense to everybody? So, Bob, if you will kick it off.
Thanks for inviting me here today. Appreciate the opportunity to talk to you about this issue. So as the FCC begins to grapple with the application of Section 222 and how it applies to broadband generally and broadband internet access specifically, I think it's important for the agency to have a baseline understanding regarding the data technologies, the different data technologies that exist throughout the internet. And my point for all of that is to say that the data collection capabilities of internet service providers, at one time they may have been unique, and we may have been in a better position to collect data than almost anyone on the internet. As technology has evolved, I would tell you that the data sets that we have available to us are not unique at all. What do we have available to us? Well, we know location, right? So on a wireline network, we know where your internet service is. In the phone situation, we know what cell towers you're connected to, and we can derive location based on that. We know, as Professor Blaze explained, when you type in an internet query, we translate that into an actual IP address, and we know where you're telling us at the beginning where you want to go on the internet. We know who you call. That's part of the metadata that Professor Blaze referred to during his discussion. We know who you text if you're using our SMS texting service. We have that information available to us. But when you think about how the technology on the internet has evolved, that's not a unique data set to anybody. URL information. Your web browser captures exactly the same data that we have about where you're going to go on the internet. Technologies have been deployed on all of the endpoints of the internet. So we know where you want to go at the beginning, but we all know that if you download Ghostery, you can find out which companies have pixels or widgets or some kind of script running that can identify the user when they arrive at a website. So that type of information in terms of tracking where people go on the internet is very extensive, and literally hundreds of companies have the ability to do that. What page do you go to on the internet that doesn't have a Facebook like button on it? There are all kinds of companies that are providing these technologies that can create the exact same portfolio of where you go on the internet. And by the way, when you're on a mobile device, half of the traffic on a mobile device is being carried over Wi-Fi, so it's not even being carried over our network anyway. But all of the endpoint technologies will still know where you're at and where you're going to on the internet, even if the ISP isn't going to have that capability. There's also techniques out there, that are being utilized in this world on device fingerprinting. So what they're doing is, whenever you go to a website, you broadcast the browser that you're using, the version of the browser that you're using, and a number of different points of information. I think Professor Swire has referenced device fingerprinting in his testimony. He'll talk later on this afternoon. Those technologies are available for people, all with the idea that says, when this information, when we see this set of information show up on a website, we can identify the individual user. Cookie technology, same idea. You show up on a website, script is there, it recognizes the cookies that come in. In terms of telephone number called, sure, we have that information, but every one of you has a phone app on your phone that collects the same data. Some of you use Google Voice. The Google Voice application collects all of that information. For us, ironically, that's treated as CP&I. We have certain rules that apply to it. Google's filed several documents at this commission demonstrating that who you call and who you receive calls from on your phone app is an information service to them, and the CP&I rules don't apply. Location, I referenced that before. Location, sure, we know the cell tower that you're connected to, but all of your devices have GPS chips in them. And all of those GPS chips are making location available not only to the OS provider who's built the application into the phone, but also to the other apps that are doing business in that environment. If you go into the Google Play Store, I think the default setting is that most of the apps you download are going to request and receive location information on your device, and they're going to associate it with the ad identifier that Google puts in their stream or that Apple puts in their stream, and so the location will be identified to a particular user on the internet. So all that goes to say that the information that's available to us is not unique, and in many respects is not as complete as the data sets that are available through the technologies that are currently in use. And I think it's important to understand that if you're going to move into this environment, you should understand the totality of the data collection that exists out there and how this fits into it. And the reason that it all fits into it is for advertising. People are using this information to serve ads. And the ad-supported business model, some people don't like the ad-supported business model, but the reality is that most consumers want cheap. They want cheap, and a lot of companies are entering our space. Look at our voice revenues, our text revenues, and they're entering our space with ad-supported models. So we have to be able to compete at that level. The second point that I would make is a point that I'm going to use a terminology that Jules Polonetsky, I was at a conference last week, and Jules spoke a lot. 1 minute, yeah? It's the data has been democratized, is Jules' point. And I'll be very quick and wrap up. I knew 3 minutes was going to be tough for me. But what that means is that you no longer have to be a big company with script running on thousands of websites anymore. Data is available commercially. I was going to bring with me, and I will provide for you a copy of the Blue Kai Blue Book. Blue Kai is obviously a company that's owned by Oracle. They published a book with about 60 different data sources in it where you can buy data. You don't need to be a big company anymore. You can buy this information from Blue Kai, and it'll be categorized for you by interest category, by zip code, by Google ID, by Apple ID. All of this information is available to any business that wants to engage in advertising on the web. All they need is a credit card to be able to go and buy this information. So I tell you that our data set's not unique, and it's available out there to everyone. So when you work in this space, I think my message to you is we have to have the ability to compete in the advertising space in order to be able to provide ad-supported services, because more and more those are the business models that consumers are generating towards. The FTC has traditionally regulated advertising, and they've done a pretty good job of it. And I would say that you should work hand in hand with the FTC in this area. Do this on a consistent basis, whatever rules. But understand, do the data gathering to understand exactly what you're dealing with out there, and then set policies that are consistent irrespective of the underlying technology that's being used to deliver the services. If you don't do that, and we can't compete in an ad-supported model, and that's what the market wants, and that's what consumers want, we're going to end up with the opposite of what 706 wants, which is more investment in broadband infrastructure.
Thank you, Bob. So I did give Bob a little extra time because he was laying the groundwork for the panel, and we have a little extra time. Plus, John Verity swore he's going to clock in at 90 seconds, so the rest of you can see if
firm commitment.
He holds. If he holds to that. Josh.
Thank you, and thank you for convening this workshop and inviting NTCA to participate. I think that the context in which this workshop takes place is illustrated by the fact that we now have companies that have a chief privacy officer. Surely illustrates where we're working. NTCA represents nearly 900 rural communications providers. Our members include commercial companies, cooperatives. We have some municipal networks, municipally operated networks as members. We have tribally owned companies and non-tribal companies that serve tribal areas, and all of our members are broadband deployed. I think time and probably your interest precludes my description of each of the policies of our 900 members. But having spoken with several of the management firms who provide consulting services to our members, I was able to confirm that our members do certainly collect personal information that they need to create billing and account information. But they are generally understood to not collect data that relates to their browsing habits or other usage. In regard to the personal data that they acquire in establishing accounts and billing for broadband access service, generally they treat these the same as they treat the data for their regulated lines of service. There are two reasons. One, there is an administrative efficiency of maintaining a common set of protocols. And two, these are small community-based companies that maintain what I call a sociological incentive or a personal commitment to maintain the privacy of their customers. In each of my conversations with the firms that provide these services to our members, they did evidence that sort of close and careful attention and maintaining a consistent consumer experience. As regulatory oversight may evolve to include formal rules that address with specificity broadband internet access service, we identified several touchstones in the consideration of how Section 222 may be applied to broadband internet access service. Those are notice, choice, and security. The consumers have the right to know which information may be collected, how that information will be used, and an assurance that consistent with reasonable consumer and market expectations, and again, whether we enter into qualitative or quantitative standards, that that data will be protected. Ultimately, strong, technology-flexible, self-regulating standards will be well suited to keep pace with the dynamic field. Our members are interested in maintaining secure networks and the confidentiality of their consumer data. It's a commitment that requires their reasonable oversight. They view this as not just a wise as a decision implicating perhaps some legal implications, but also a wise business decision. And I look forward over the next hour or so to sharing ideas with the panel and the audience.
Thank you, Josh. Laura.
Thank you, and thanks so much for having this workshop and inviting me to speak. So I think that where I'd like to start framing things from the consumer perspective is with the idea that privacy is not a simple, no longer, we don't think of privacy anymore as a simple distinction between private information and information that is not private. Consumers have a much more complicated relationship with privacy, and it has to do with the context in which information is provided. So privacy is very much contextual. There has been many privacy experts have written on this issue, and as a society, we have norms about the appropriate ways that information should flow, and that's why there's certain information that we might be willing to share with a friend, but we feel that our privacy is violated if, for example, that information is shared with our boss. It depends on the context in which the information is shared, and we have norms that we expect to apply to that information. So that said, in the context of communication service, I think consumers expect that information they have no choice but to share in order to obtain an essential service won't be broadly shared with other parties. For example, if they visit a website for Planned Parenthood or the Craigslist Casual Encounters advertisements, if they visit an online auction house for firearms, they don't expect that the gatekeeper of the network is going to monetize that information in a way that would violate their expectations of privacy with respect to that information. And I would argue that these are norms that we as a society want to support for important policy reasons. So for the same reason, for example, that we have special rules that apply to health information when provided with healthcare providers, the policy thinking there is that we want to support candid and open relationships with doctors and other healthcare providers, and that makes sense. We want patients, in order to obtain the best service that they possibly can, to share their information in a way that's open with their doctors. For the same reason, many of us in this room, I know, are lawyers, and our ethical obligations to maintain the confidentiality of the communications that we have with clients is, as we know from our ethics classes, something that was created as a way to encourage clients to have candid and open relationships with their lawyers. So there's policy reasons to have special privacy rules that apply to particular relationships in other contexts. And I think that in communications, this is the case as well, and it makes a lot of sense. When we're dealing with communications, what we're trying to do is we're trying to foster confidence in the network as a reliable platform for free and open communications. We want people to be able to speak freely and openly when they're using essential communications networks. That's an important privacy consideration. So then my final point that I'd like to open with is that as gatekeepers for an essential service, then broadband providers are in a unique position to have an invasive view of personal communications. So we saw some of this in Professor Blaze's presentation, and I think, notwithstanding some of the points that Bob made, there are certain things that ISPs certainly have a view into, and we saw this with the Verizon perma-cookie. This was something that AT&T was similarly doing at the time, injecting headers into traffic of their customers. We know that many ISPs provide DNS servers and have a view into DNS queries. We know that many ISPs provide the Wi-Fi routers for their customers' home communications, and through that can see lots of information about customers' devices that they're using, their personal devices that they're using at home. Not to mention, of course, all of the information about traffic that ISPs can use. So I think, given our interest in maintaining the contextual integrity of this network as a platform for free and open communications, it's important for us to consider that information ought to be, that ISPs ought to be held to a high standard with respect to that information. Thank you.
Thank you, Laura. Michelle.
Thank you. I'm really happy to be here today to talk about an issue that is incredibly important to my boss, Connecticut Attorney General George Jepsen. And this dedication was shown by his creation of a privacy task force in our office in 2011. At the time, data breaches had become a significant and growing concern, not only in our state, but across the country. And in the past several years, our office has led investigations of massive data breaches and other significant issues involving consumer privacy. Attorney General Jepsen recently formed a dedicated privacy and security department in our office to ensure that our privacy work maintains this level of commitment going forward, and because the need for this work is so great. Turning to today's topic, I'm not a telecommunications expert, but I hope to weigh in drawing on the regulatory and educational work that my office has done in this area, and also as a consumer and broadband customer myself. And to do that, I just wanted to give a very quick overview of the state laws that we enforce, because it's what will inform our views on the discussion today. First, we have a data breach notification statute that requires notice both to our office and to affected Connecticut residents when a breach does occur. We also have a general safeguard statute, which requires anyone in possession of personal information to safeguard it. And the statute defines personal information very broadly. It's basically any information that can be linked back to a person based on one or more identifiers. And then finally, in enforcing privacy cases, we often look to our general unfair and deceptive trade practices law. So while my office hasn't dealt specifically with broadband providers yet, we have handled a number of cases involving new and innovative technologies, which of course raise new and unique questions about consumer privacy. In those cases, we ask the same questions. What information is being collected? How will it be used? How will it be stored? What safeguards will be in place to protect that information? Will the information be shared? If so, to whom? What are consumers told about this? What level of notice are they provided? What level of choice are they provided? What level of control are they given? We've seen cases where consumers have had no notice of information collection. And an interesting example there is our investigation of Street View. There, Street View vehicles were driving around connecting to personal and unsecured Wi-Fi networks, collecting information transmitted over those lines. People had no idea that was even possible, let alone happening. And another example is our work with some recent investigations dealing with cookies. We recently entered into multi-state settlements with two companies that were overriding consumers' browser settings for related to cookie blocking, so that those cookies could be placed in contravention of consumers' actions to prevent that. Now, in the data breach context, our office reviews receives and reviews over 400 data breach notifications per year. And they range in size. Some are submitted by small businesses, some by national corporations. At the least, there's one impacted consumer, and at the most, there's millions. And so while no two breaches are created equal, and neither will our expectations be for any given breach, what is consistent across the board is our expectation and the requirement that reasonable safeguards be in place to protect personal information. And that, in our view, is largely tied to the nature and the scope of the information at issue. So an example there is a recent case that we brought against a national bank where they knew of a technical vulnerability that existed and that allowed access to customers' online banking information, and yet nothing was done to fix it. So what does all this mean in the broadband context? Like I said, I'm not an expert, but as I understand it, because of the nature of broadband, it really does allow a unique situation with respect to the collection of personal information. And in our view, and we don't think this is controversial, consumers should be afforded as much notice and control over what information is collected. So it seems like even though this is something new, this is a new technology, we should be asking the same questions here about the extent of information collected, what's told to consumers, how specific is that information, is there notices to consumers in plain language so that they can understand it, not just that it's there, but that it's something that people will read and understand, and just how much level of control will consumers have over that collection.
Thank you, Michelle. I think that actually probably segues nicely into what Catherine's going to talk about.
Okay, wonderful. Well, thank you for the honor of allowing me to speak today. So I'm going to make 3 points. The first point is generally when anyone talks about advertising, they bring out that old chestnut, which is sometimes attributed to John Wanamaker, which says that 50% of my advertising is wasted. I just don't know which 50%, and that's the trouble of advertising. Now, let me be clear. On the internet, that old chestnut is no longer true. Instead, we know quite a bit about how well advertising works. And what we've found out is that in general, online advertising is pretty ineffective. Let me give you some numbers to illustrate what I mean by that. So if you have a perfect randomized controlled trial where you show someone an online ad or you show them a placebo, then when you show them the actual ad, at most we're seeing a lift in their stated purchase intent of around 2 percentage points, right? Very small. Now remember, this is just a stated preference. It's not whether they're going to actually do anything. And so if we actually go and look at when people actually do stuff in response to online advertising, I've got colleagues at Yahoo who've tried to measure that, and what they've generally found is that even with millions and millions of observations, you just can't get a precise answer, right? It's such a small effect, it's just too hard to measure. Now, you might think, well, gosh, well, doesn't that just mean that if online advertising is so ineffective, why do we all care about it so much? So I want to sort of bring myself onto my second point, which is, well, online advertising is pretty ineffective when we don't have data. As soon as we add data to online advertising, because in general it's just so bad, any incremental improvement looks huge in terms of percentage points, right? Add some data, we get a lift of 1,000%. And that's why we have to understand why data is so important to this industry. Generally, a random online banner is going to do absolutely nothing. You need data to make it work. And I'll actually give you some numbers on this, which come from some of the research I did into the effects of European attempts back nearly 10 years ago now to restrict the use of data in online advertising. And what I measured there was that relative to the US, we actually saw a decline in online effectiveness of ads in Europe of 65%. And I want to emphasize these were, notice and consent cookie type rules. They weren't particularly harsh, but because data is so important to the industry, you can move the needle in quite a profound way when you shift access to data around. Now, the last point I want to make, which sort of comes out of this online advertising world, is that Dr. Blaze talked about intrusion. And I want to just refine that argument a little bit. If we believe, I think Mr. Quinn was talking about this, that in some sense we have an online advertising-supported internet, people have become accustomed to it, we have to think a little bit about what kind of ads we want to support it. And in general, I distinguish between two types of intrusion. One type of intrusion is the use, say, of deep packet data to customize and tailor ads towards a certain individual. Another type of intrusion is, think back 10, 12 years ago, what online advertising looked like. Do you remember those floating banner ads with moles that you had to hit and it would just float over your internet page, right? That's a very different kind of intrusion which can also happen online. And what I found was when we looked in Europe at what had happened as we try and restrict the uses of data, is that the use of those intrusive types of advertising, the more pop-a-mole, floating over your page, their effectiveness actually made them more attractive there, because you could still get people's attention through interrupting their browsing experience rather than trying to get their attention via tailoring. So in general sense, if we're going to have an advertising-supported internet, we also have to be careful that by inadvertently shutting down access to data to tailor advertising, we're not going to end up with more floating, intrusive pop-up ads in its place, which may also be undesirable on the part of consumers. John.
John.
Okay. Well, thanks so much for having me. First, I just want to flag that one of the things that NTIA does is we convene multi-stakeholder engagements as part of the President's Consumer Privacy Initiatives, where we bring industry and civil society and academics and tech experts together to try to develop codes of conduct on important commercial privacy issues. While back, we did one of these initiatives and we convened one of these engagements around how to better provide privacy notices on mobile devices. And that group talked about a lot of things. It talked about, privacy notices. It talked about data collection by ISPs, by online service providers, by apps, by others. And I think that group raised three broad points that would be helpful to keep in mind as we think about these issues. First, it's that ISPs don't just play one role within the internet ecosystem. They play multiple roles. So sometimes they act as broadband service providers, as Professor Blaze talked about, transiting packets back and forth between a user and an online service. Sometimes they act as mobile app providers. ISPs, the same companies that provide broadband service, that provide ISP service, also have their own mobile apps that one could download from an app store and use on their mobile device and interact directly with the consumer. So it's important to think about how these entities play different roles within the ecosystem. 2 points kind of flow from that first one. That is, depending on the role that ISPs play within the ecosystem, that has implications for how they influence data that's collected or how they don't influence data that's collected, depending on their role. Second, the group talked a lot about how, depending on the role that ISPs or others play within the ecosystem, that has an impact on how privacy notices and privacy controls are provided to users. So as we talk about broadband privacy, and as we talk about ISPs acting within the stack, the internet stack, or acting within the online ecosystem, or acting within the wireless ecosystem, I think it's important to keep in mind that these entities are often playing multiple roles, and that's going to have an impact on how data is collected, how privacy controls are provided, and how privacy notices are provided to folks. I don't know if it was under 90 seconds, but it was close.
It was not under 90 seconds, but it was pretty impressive. And all of you, thank you so much. You have all successfully put enormous numbers of issues on the table, which was the point of this panel, and left us lots of time for questions from us, your moderators, and from the audience, both here in the room and on the web. So Chris is going to kick off the question.
Hi. First of all, I want to thank the FCC for holding this workshop, and I appreciate the opportunity to participate as a co-moderator with my former colleague, Lisa Hone. Bob encouraged the FCC and FTC to work together on these issues, and I appreciate that word of encouragement, but I actually don't think it's necessary because the FCC and FTC have worked together successfully for a long period of time on privacy and other issues, and I expect that to continue for the foreseeable future. The first question I'd like to ask is sort of drilling down a bit on the consumer expectation point. I think Laura and Bob both addressed this. Catherine did to a certain extent as well. Laura mentioned the notion of going to Planned Parenthood, providing some information. There's a certain expectation that that information is not going to be used for additional purposes. And I think Bob offered some discussion of how there are other data collectors out there in a position to collect as much consumer data as ISPs are. So drilling down on that a little bit, do consumers have a certain expectation in dealing with their broadband service providers that they wouldn't in another context? And I'll throw out a couple of examples. Let's say Apple in the use of mobile devices, or Google in the use of the variety of services that Google provides. What expectations do consumers have about their interaction with those types of companies, and does that expectation or changed expectation make a difference in how we approach these things? I'll throw that to Laura and give Bob or Josh an opportunity as well, and anyone else.
Sure. Is this working? Hello. Okay. Great. Okay. So a couple of things that I just want to start with there. One is that, when we're talking about other parties with access to the same information, I think that, again, it's important to remember that this happens in other contexts as well, right? So in the health privacy context, we are now grappling with the problem of devices like Fitbit that might provide another party with enormous amounts of access to enormous amounts of information about an individual's health status. But that said, no one's using the new existence of Fitbit and related devices as a basis for arguing that we should just do away with HIPAA for protection of health information as accessed by doctors in the context of providing health service. And so I think that raising these issues of there being other actors in the chain of communication between an individual and whoever or whatever entity he or she is communicating with over the internet, those are really important issues that we need to deal with. We need to deal with what happens when Apple or Google has access to enormous amounts of information through operation of the operating system on the device. But the mere fact that there are these other actors in the chain does not mean that we should stop protecting the information that the network provider, as the gatekeeper to the essential network, has. So that's one point that I wanted to make. Another point that I'd like to make in response to this is that consumers do consider information about their communications to be uniquely private. So a Pew Research report from last fall found that consumers considered health information to be sensitive or very sensitive. 81% of respondents said that. Location information collected by a device was 82%, so even more sensitive. Numbers called, that was 75% considered that to be sensitive or very sensitive. And websites visited, that's 70% consider it to be sensitive or very sensitive. So consumers do consider the information that common carriers have access to be particularly sensitive, and we have an obligation to protect that information.
Bob, did you want to, or Josh, or did you want to?
I'd be happy to respond to that. And I wasn't suggesting that we throw away the CP&I framework, because I don't think that's that's the right answer either. I think, where we come from is HIPAA was a great law, but it's entity-based. And I think the evolution of the Internet has demonstrated to us that just doing entity-based regulation is really kind of a last-century approach to privacy. I mean, because at the end of the day, and I don't mean to pick on Fitbit, but everybody knows what that is, but if you have a medical device that's tracking all kinds of really sensitive and very personal health information, the fact that the HIPAA law is out there, that doesn't really help you when the entity that's collecting the data is not a designated entity under HIPAA. And I just think that's a backwards approach. And what I tried to articulate is, in what I was saying earlier, is the approach really should be consistent. We should really kind of take a consistent approach. You guys at the FTC and the FCC should work hand in hand. And whatever we do in this space, we can have a debate about which information is sensitive, which information is not, but we should do it on a consistent basis. That's the way that I think consumers expect their data to be protected. Shutting down, saying, okay, you're restricted as an ISP from using location when every single app in the Android environment is getting location data that's better than the ISP has, I don't think that really is meeting any kind of consumer expectation of privacy. And I guess my suggestion was that the way we did this on an entity-based approach in the past is no longer a valid way to approach this on a going forward basis in the Internet, and it's not really a sound public policy. To address very briefly the point that you raised about the Planned Parenthood example that was made, I will tell you that the way that we've approached our privacy policy, and we did a massive rewrite that I'll credit Dorothy Atwood for overseeing when she was our chief privacy officer. She was our predecessor, and she was very, very good at this. Dorothy rewrote the privacy policy, took like 17 policies, made them into one, made it plain language. And the approach that we take is, if we're going to use your personal information in any way, shape, or form to target any kind of advertising or anything to you, that's got to be done on an opt-in basis. And we haven't really developed that. We've got one opt-in service for Gigapower down in Austin, Texas. We've rolled that out in Kansas City, which has a reduced internet access fee in exchange for being able to use the web browsing data for advertising. I don't think we've actually operationalized all of that yet, but we're in the process of trying to figure that out. But the idea being, if we're going to use anybody's personal information for purposes of advertising, we would do that on an opt-in, and that's very clearly articulated in our privacy policy.
Sorry, can I just add just a couple points here? So one, I just want to emphasize that I do think that ISPs are in a unique position to have comprehensive information about customers' communications over the network. So, one, as we have seen, they can engage in deep packet inspection of every single piece of information that a customer sends over the network. Two, they can see every single DNS query. They can see, every single site that a customer wants to visit over the network. I mean, these are sensitive pieces of information. And third, when I call customer service for my ISP and I'm troubleshooting my Wi-Fi network, one of the things that they might ask me is about the devices that I'm using over the network, and they can see information about those devices just through the Wi-Fi router that they have provided, that they often force me to use as a customer of a particular service. They don't allow me to choose my own Wi-Fi router. There's a lot of information that ISPs have unique access to, and so as I mentioned before, I do think that it's important to treat information with rules that are specific to the context in which they're provided, and you might be characterizing that as entity specific, but I think that it's context specific and context respective. But two, in addition, ISPs do have access to different types of information and a comprehensive set of information.
Sounds like we have consensus. I have one quick follow-up. I don't think we touched on this much, but this is, again, a consumer expectation point. And it's really how we approach these. How should we approach these issues? Should we care more about ISPs' collection and use of data for their own purposes, Or should we care more about the ISP collection and sharing of that data with other entities for potential new uses or uses by third-party entities? I'll throw that out to any member of the panel.
I mean, I'll take it, but since I just finished speaking, I wanted to give someone else an opportunity. I absolutely think that there are certain internal uses of information that are less concerning. There are certain types of traffic management that might require the use of information, but concerns are raised. I mean, it depends on how the information is being shared, even within one entity, right? I mean, once we're going from some sort of traffic management to advertising, then there are concerns about how that information is being shared because the consumer may not have consented to that. But even when it comes to traffic management, there are also always going to be certain types of traffic management that raise concerns, of course, in the net neutrality context. And that's something that the FCC will have to grapple with. But I do think that there's certainly a need for concern when ISPs are sharing information with third parties, but even within one company, when they're sharing it from one part of the company that's doing traffic management purpose to another part that's doing advertising, there are additional concerns as well.
So we have a question from the audience that sounds in this, but let me just let everybody who's here in the audience know that there are people circling with cards, and if you have a question, you're welcome to write your question on the card, and they will pick up the question. So this is a question for you, Mr. Quinn, but also at least towards the end for you, Mr. Seidemann. And the question is, does AT&T in its provision of Internet access services observe when your customer visits a website of one of your competitors and use that fact for retention or win-back? If not, why not? And should the law prohibit doing so? And the card says, Josh, that this last question is for you as well, since you made a representation that your members don't collect browsing information. But let me put that in a slightly broader context, Bob. So you specifically said, I think, that AT&T in only limited circumstances uses customer information for advertising and provides notice and choice when it does that for advertising purposes. But I think the broader question is, does AT&T as a broadband provider collect other information about consumers, and does it always provide notice and choice, and or does it use that information for purposes other than advertising?
Well,
so there's really two parts to that question.
Yeah,
right? There's the notice and choice question, and there's the collection and use information.
So I'm going to go back to what I told you before, which is if we're going to use your individual information, we're going to do that on an opt-in basis, right? So if we're going to use the fact that you went to the Verizon store and use that information for any purpose whatsoever other than providing the service or improving the network, that's a big exception, so I'm going to talk about that because that was kind of associated with the last question that you asked. We would do that on an opt-in basis. We wouldn't do that on an opt-out basis and do that. So my answer to the question is no, we don't do that today. And if we were going to approach that, it would fall into the way that we've described how we would use information, which is if we're going to use your personal information, we'd require an opt-in in order to be able to use that to do advertising or any kind of marketing to you. Your question about exceptions to that, and we're very clear in our privacy policy about that. We need to get certain information from you in order to be able to provide you the service. You got to tell us the phone number you want to call in order for us to complete a call. You got to tell us the website you want to go to in order for us to be able to connect you to the website as your internet service provider. And we do use that information to improve networks. So if you have a drop call or some kind of an event where an internet session has been interrupted, for example, on the wireless infrastructure, we use that information to figure out, do we have a problem in this area? We got a signal or a connectivity problem? And we use different kinds of network tools to be able to identify problem areas in our network and improve the performance of the network and consequently the performance of the service that we sell. We do not allow people to opt out of that. I mean, we're very clear in our privacy policy that our collection and use of data for that purpose, you can't opt out of it because we use that data in order to figure out how we can improve the network and how we can ensure that you have connectivity whenever you're out there in our infrastructure. And I think that answered the second question that you asked, and we explain all of that in our privacy policy.
Okay. And Josh?
Yeah, again, based on my conversations with several of the firms that serve our clients, they do not generally collect that information. One of the consultants could remember one time, again with an opt-in and authorization, that the information was shared, and that was in order to enable a school district to match up special needs students with the provider in order to provide a discounted broadband service into the home. But again, that's all under disclosure, that's opt-in. Why they don't collect that data? The only thing that I can speculate is, you mentioned the bump that even small numbers can have in small things. Big data is big data. When you're talking about 5,000 customers, I don't know that the data collected from 5,000 customers really gets into big data.
Laura, you look like you had something you wanted to say?
I can, okay, so I guess one thing that I would say here is, I'm very encouraged to hear that AT&T plans to get opt-in consent to use any individual information about consumers for purposes other than just network management. I do have concerns about what that opt-in consent looks like as well. So, recently, just in the past few months, there have been a bunch of stories in the news about AT&T charging a premium of customers who would like to not have AT&T engage in deep packet inspection with respect to their traffic over the network. And I'm curious about whether or not that constitutes opt-in consent from your perspective. Is it opt-in consent if a customer signs up for a service and then has to pay an additional fee to protect the privacy of their traffic over the network? And if that is the case, then I think that we have a real problem because from consumers' perspective, that would not be a sufficient form of consent, in part because, as I mentioned before, I'll go back to the importance of maintaining the integrity of the network as a safe space for free and open communications. If it's important to maintain the network in that way, and if privacy is going to be something that has a premium dollar value on it, then we're going to see consumers who just have less money end up enjoying less confidence in the network as a safe space for communications, and that's a real problem.
And I just wanted to jump in really quick too, and I think those are concerns that we would share. Wondering what the opt-in consent would look like. How would it be provided? How would consumers be asked to provide it? What would be specified about what types of affiliates the information would be shared with? I think sometimes people don't know just how far the sharing can go, and it's not always specified. And I guess at what stage in the process would they be asked to provide that consent, and would they be able to change their mind, and how would that work? These are definitely things that we would be concerned with too.
And John, I know NTIA has done some work around this. Is there anything you want to add on the notice and consent question?
So yeah, sure. So in terms of the notice and consent question, I think that I would sort of go back to my introductory remarks, which is it really matters what role ISPs are playing, because as folks know, ISPs have lots of contact information and lots of ability to contact users because they have account information, they get paid for their services, they typically know the user's email address, they're able to reach out to them in different ways when they're acting as ISPs, right? And then when they're acting as app providers or other service providers, there's a question about whether those usernames or those identities are linked. And those app provision roles and service provider roles have different mechanisms by which they can provide notice. They have different mechanisms by which they can provide controls. And the ISP, when it is just acting as an ISP without an app installed on a particular device, doesn't really have the ability to push notifications and notices in the way that an ISP does when they have an app installed on the device, and they can take advantage of those hooks into the mobile operating system that the app provides, right? And there are some very limited exceptions to that for, emergency weather notifications and the iPause system and things like that, but they're very, very narrow and very, very limited. So I think it's just important to be mindful of what the options are that are available to ISPs at different, given different interactions with consumers, and also how those interactions with consumers merge within the ISP or don't merge within the ISP.
And Bob or Josh, do either of you have thoughts on best practices for notice and consent from ISPs?
I think what we tried to do is we tried to create with our GigaPower offering an ad-supported model and a non-ad-supported model. And I think what we're trying to figure out is what works in this area in order to be able to compete. As others enter the space and others enter the space of the services that are provided, we've got to be able to compete with people who are subsidizing their services with advertising revenue. So I think we created, the product has been in the market for a year and a half, more than a year and a half down in Austin, Texas, and I think we created a way for customers that they could have a choice whether they want an ad-supported model or not. I put that up against any of the tech companies that most I don't know any of them that give you a choice between an ad-supported model versus a non-ad-supported model. There are certain apps that I think have the pay app and the free app, and if you do the pay app, you don't see the advertising. I don't think that has anything at all to do. You just don't see the ads. So I think we've had the product in the marketplace down there for about a year and a half, and I think we worked very hard to make sure that people understood that they had a choice and they exercised the choice. Even people who have criticized us have, because they don't like the idea. Even people who have been critical of it, I think, have recognized the fact that there was a choice. People are making a knowing choice in the area and have noted, that compared to some of the ways that tech companies offer services, they wish that they had a sort of choice. So I think we're making strides to do that on a very transparent way with the consumer.
The Pew study that was referenced before noted that perceptions of privacy are evolving and are different based not only on generation and age of the user, but there is found some correlation between the education of the user as well and what their expectations are. And if I carry that over to the issue of notice and disclosure, the question is, how do you structure notice and disclosure adequately that it's not so broad that it's essentially meaningless? And I think there was an FTC case, the Conmetrics, that had a problem with a statement that was so broad that it was worthless, to the point of then making something so comprehensive that by its specificity, it then excludes certain circumstances or becomes so complex that it's also useless to the average consumer.
Catherine, I wanted to bring you back into this discussion with a question about, you talked about the effectiveness of ads online and how additional data makes advertising more effective, which supports the ad-supported internet. And I wanted to ask a question about whether you've looked at the aspect or element of consumer trust in this analysis. And there have been issues with ISPs in the past with Nebuad Inform and deep packet inspection experiments that generated significant public attention and a fair amount of consumer concern. And the concept of trust in the data collection and use, I think, is an important element of this discussion. So I'd be interested to hear your views on how that factors into your analysis.
Thank you. So I think it might be helpful to refer back to a study I did where I actually looked at how the effectiveness of advertising on Facebook changed with the evolution of Facebook privacy policies. And what I found there was that when Facebook introduced user-centric controls, that is the kind of controls where you go in and actually take control of your data, that actually improved click-through rates on ads, and particularly the kind of ads which were very personal, use sort of the more intimate information you may post on a Facebook profile. Now, I think this is important because we often think that firms themselves have no incentives to have privacy controls, so there's in some sense, firms just want to get away with what they can get away with. But what this study showed was actually it was in Facebook's commercial interest to empower users to control their own data. And I think that's sort of a part of the equation we should think of, how to align commercial interests with enhancing user trust in the system.
That's great. Thank you. One question from the audience, which I'm going to modify slightly as a moderator privilege. Bob, you mentioned that the FCC and FTC should work hand in hand on these issues. And you commented that the FCC has the CP&I rules, and you're not looking to get away from the CP&I rules. The FTC's structure is a bit different. We've got Section 5 of the FTC Act, which is a general prohibition on unfair and deceptive practices, but we don't have general rulemaking authority. So, given that difference in the set of tools that each agency has to work with, how does that affect your thinking? This is probably more for the next panel than this panel, and I apologize for that. But how does that affect your thinking in what the FCC should do with CP&I rules and maintain some consistency when the FTC has Section 5 but no analogous rulemaking?
Yeah, so, we've been dealing with this. I mean, we've been working with the Federal Trade Commission for several years. We revised our privacy policy. You guys did an investigation of that. You asked us enormous numbers of questions to be able to satisfy yourselves. But the way that we've always operated with respect to the Federal Trade Commission is, we do what everybody else does, is, you guys give speeches about your intent. You say things about personally identifiable information, and you kind of declare your intent of how you're going to interpret things. And I don't think, in the end of the day, it makes a lot of sense to have two different agencies regulating the same conduct, because I think what that leads to is it leads to entity-based regulation. And I really don't think that's the effective way to approach privacy. I think the effective way to approach privacy would have comprehensive reform and one agency kind of setting the rules. Because if what we're talking about is we're going to regulate in the area of advertising, then we ought to have the same rules around how people collect, use, retain data for purposes of doing advertising, and we should have a single policy that applies to everybody. It doesn't make a lot of sense at the end of the day if I have a bunch of rules around CP&I on who people call and who they get phone calls from, and that's all metadata, and an app provider gets the exact same information, but I have a set of rules that applies to me that doesn't apply to them. It may be that the right answer is those rules should apply to both of us. It may be that the rules are antiquated and they shouldn't apply to either of us. But at the end of the day, we should have a consistent approach to it. One way to fix that is through legislation. We've made it very clear that we believe that a legislative solution to all of the net neutrality issues, which included bringing CP&I in here and giving the FCC authority over broadband internet access services on a Title II basis. We think a right approach would be to fix all of this through a legislative approach so that we have a single agency that's doing all of this. On the other hand, that's not where we're at today. So, all I guess I can ask for is that what we would end up with at the end of the day is that the FCC kind of acts in a restrained manner to work on a consistent approach to privacy and a consistent approach to advertising that doesn't basically impede us in the competitive marketplace. Because at the end of the day, we can, if we're competing against people who are supporting their services with advertising, and we can't, and our hands are tied and their hands are not tied, it's gonna inhibit the amount of money that people can invest in this infrastructure. And I think that would go very contrary to the mandates of Section 706. So I tell you, be careful. If you work hand in hand, you can espouse the same policies and the same intent of how you're going to approach this, and just do it, as much as you can on a consistent basis.
So that invites a lot of follow-up questions, but I'm going to go outside the Beltway. Michelle, welcome to the inside the Beltway, but the state attorneys general have been very active in the issues of privacy. So do you want to touch a little bit on this theory that there should be one agency responsible for privacy, and what the roles of the...
I got to make that clear. One federal agency.
And we often work with federal agencies as well. And I think it hasn't been a deterrent. It has only strengthened consumer protections. It's really important. I think. I don't know. I guess just that's the type of work that has been very beneficial to consumers, and some of the best cases that have come out of our office have been cases that we have collaborated with other agencies, and there hasn't been any disadvantage to those cases, in my opinion.
And Laura, I know some of what Bob said sounds and things you've already said, but are there some themes you want to sound there?
Sure. Yes. Well, I will return yet again to the importance of what I know what you're calling entity-specific regulation. I would call context-specific and context-respective, and say the FTC has done a lot of fantastic work on privacy. I have worked very happily with the FTC on privacy issues, and in the context of their enforcement of Section 5, they do a lot of thinking about privacy in terms of what might constitute unfair and deceptive practices for consumers. But the FCC's approach is a different approach with a different framework, and that is appropriate for gatekeepers to the network. So the FCC has also done a lot of fantastic work on privacy, and a lot of fantastic work dealing with gatekeepers in particular in a variety of contexts, not just with respect to privacy. And their framework is really about, as I mentioned before, fostering confidence in the network as a safe space for free and open communications. It's a different approach. It calls for prospective rules, which I think is very important. And I know, Chris, that's something that you highlighted. The FTC unfortunately can't do in this space, and it is helpful as a way to level the playing field from as technologies are developed moving forward, to make sure that carriers know what their obligations are with respect to consumers' specific private information. And then I just also wanted to touch a little bit on this competitive concern that I also hear Bob raising with respect to whether or not ISPs are able to use the private information of their consumers, and say that there may also be competitive concerns on the other side. And I think it's important for us to not to forget that there could be competitive concerns raised when we have ISPs exploiting their gatekeeper relationship to compete with advertisers who perhaps don't have that gatekeeper relationship and don't have access to the same information that a gatekeeper has in the advertising context.
I just want to follow up a bit on the discussion of competition issues and ask about whether the broadband marketplace is not, I don't think, a universal marketplace, and there are different competition-related environments that exist in different locales. There may be some areas where there are very few broadband providers providing service. So there may be situations where consumers, if they're not happy with a particular way in which one provider is providing service or using data or collecting data or providing notice about intended uses, there may not be options for that consumer to exercise, the competitive choice of selecting another broadband provider. How much does that matter to this discussion? How much should we care about that as we contemplate regulation in this area?
I think that issue is less relevant in this area, because I think when you're talking about the marketplace that you're talking about is essentially what the data collection is going for is for advertising, broadband advertising, information to be used on the web. And I think that in today's environment, where on mobile networks more than 50% of the traffic is offloaded onto Wi-Fi, you're using Wi-Fi at home, you're using Wi-Fi in a whole bunch of different locations where it's being deployed. You've got mobile providers, 4 national mobile providers, several regional mobile providers doing business in the space. And when you look at the technologies that are being utilized, as I said before, we're not in a unique position in order to be able to understand where people are going on the internet. We don't even have the most complete picture, although I think we could buy it out there, because I think there are enough data brokers out there selling information that it really is in a lot of different places. So I think from that aspect, if what you're going to focus on is the use of information for advertising, I don't think that fact plays a big role here at all. I mean, I don't see it as playing a big role.
Oh, we're working on that pesky data broker situation.
I know you are.
Catherine, did you want to comment on this?
I just wanted to just make one comment on the interaction between privacy and competition. What always worries me is how privacy regulation may affect the fate of future entrants or future potential competitors. And the analogy I always have in mind is, let's go back to 2000 and think about Alta Vista and Google. And what would have happened is, if we'd had extensive opt-in privacy regulation to do with customers' data at that point, is there a chance that customers may have stuck with the more trusted provider, that we may still be in a world where we have Alta Vista and not Google? And is there a potential for, rather than a sort of allowing competition and choice, for privacy regulation to further entrench, with apologies, firms like AT&T and so on, and prevent future competition?
Did anyone else want to comment on that particular issue?
I have a follow-up question, which is, Bob, your answer explicitly assumed that the data being collected, although it's not clear what data is being collected, but if there is data being collected from broadband providers, and to the extent there is data being collected from other entities in the broadband ecosystem, it's being used for advertising, and that somehow means it's not so important. But I guess my question would be, is that right? I mean, data can be collected for lots of purposes, not just for advertising. And if it's collected for other purposes, does that change your answer? So one of the questions from the audience we got was a question about using data for win-back or customer retention. But it can also be used for pricing, right? Insurance pricing, for example, is one that we've heard about in the media, or for other purposes of which consumers may or may not be aware. So is there a difference in your mind, and this is to Bob because you raised it, but to others, for what purpose that data is being used in terms of the significance of the data collection as well as notice and choice?
I think the predominant use of that, other than, for example, for an ISP, I mean, I could think of at least, 3 different uses. One is research, making data available for research. One is to actually operate the network and provide the services that we sell. When we think about it, the third is really marketing and advertising. I'd throw the win-back into a marketing type of scenario, that you describe that as kind of a marketing use, and that's basically the kind of the 3 buckets. I think that's the predominant use. There may be other uses. There's certainly nefarious uses, as we have learned through data breaches, et cetera. But I think the predominant use case that's out there that people are building for is really in the area of advertising and marketing. And I don't mean to say it's not important, because with all respect to Professor Tucker's research, which would say that the advertising isn't very effective, it still drives an awful lot of what's going on the internet, and it's certainly driving, the innovation, because that's how a lot of these use cases are being developed, and they're being supported on an ad-based marketing plan.
Yeah, I mean, I think that there are absolutely concerns about other possible uses of information, and I know that Bob and others have mentioned data brokers. One of the reasons that data brokers are such a concern right now is because once information is shared with a party, it's very difficult to control downstream uses and sharing of that information. And I think that we need to be mindful of that in the context of dealing with ISPs. Once we say that private information can be used for advertising purposes or can be shared for advertising purposes, then we have to be concerned about what the possible downstream uses of that information are and how that information might be collected and by parties that are capable of aggregating it and cross-referencing it with other data sets that raise additional concerns.
So, can I jump in? And I hesitate to agree with Laura because we haven't agreed on a whole lot today. But I do agree with that, and I keep going back to the notion that our data set's not unique. Location data, that's a great example, right? The default setting for location on an Android app is going to be to disclose, most of the apps that you download ask for the location of the phone. It's associated with the Google advertising ID. Once they have the location of the phone, they can go to Axiom and they can go buy demographic data, and they can append the demographic data and create a profile of the user based on the income, based on the education level, based on the cars. I'm amazed that today, if I travel overseas, I will invariably try to use my credit card, and the credit card company will tell me that I can't use my credit card because I have a fraud alert on it because it's not within my algorithm. And when I'll call them, what they'll ask me what cars I own. And so I'm like, I didn't buy my car with this card, right? But that's data that they've purchased, right? And they know what cars I own, and I have to give them the answer to that. But that's what I mean. I think consumer expectation is that we're going to deal with these issues on a consistent basis, and we're not going to kind of create this false barrier that says, well, I'm going to restrict the ISP, and I'm going to give the consumer a false set of security that somehow all of this other information isn't going to continue to flow. And that's why I just argue that's why I say, Laura, that an entity-based approach, it had its effectiveness at one point in time, but on today, I just don't think it really meets consumer expectations.
And if I can just jump in just for a second, and I'm sorry to sound like a broken record, but I'm going to repeat some of the things that I said again, which are, one, that even if the data set is not unique, that doesn't mean that we stop regulating it. It doesn't mean that we get rid of HIPAA. It doesn't mean that we get rid of Gramm-Leach-Bliley. We're not going to get rid of the important privacy protections that are meant to protect special relationships, much like the special relationship between a customer and a gatekeeper to an essential service, particularly, as you guys brought up, when there are very limited choices often, many times only one choice for high-speed broadband access available to consumers. So they just don't have a choice. And the other thing is that I have to continue to disagree with you about whether or not ISPs are uniquely situated to have a comprehensive and rich, a comprehensive access to rich information about their customers' use of the network. All of the traffic flows through the gatekeeper. The gatekeeper is uniquely situated to absorb a lot of very personal information.
I would have to agree there, and I just wanted to point out that I think there's an assumption being made that consumers know and understand all of the pieces of information out there being collected by apps and other services, and they're fine with it, and that they know that all of that information can be aggregated, and they're fine with that too. And then I would just have to second that I would be very surprised if it were the case that broadband providers aren't in a unique situation to collect this information in one place by the provider because of the access of that service. So I think it is a very different situation.
Josh, you look like you're desperate to speak.
Not that desperate. I think the FTC has a great umbrella. Is it unfair or deceptive. And that's a qualitative standard. So I'd find it a little bit creepy if I was using my credit card and Visa asked me what I drive, but they could know that information by standing on the corner and watch me pull into my garage each night. So there are different sets of information that consumers view as more private than the other. And the Pew Research study found that Social Security numbers and phone conversations and health information, that tops the list. But media tastes and shopping, consumers just don't view that to be as private.
I hate to do this with 5 minutes left, but I'm going to introduce a new topic very briefly, though, and hope that we can have an interesting discussion about it. This will be the last question. So we've talked about different potential data uses by broadband providers. I want to throw out a question about whether there are specific practices, data use practices by broadband providers that we should simply say are off limits. Whether it's use of sensitive data, however we define that, or some other practices by broadband providers that we would say even in a notice and choice world, we're not comfortable with that happening. So I'd open that up to the panel.
And in fairness to the panel, we didn't warn them about this one. So.
Well, that's what makes it so interesting.
My answer is easy and predictable.
Laura, do you have any thoughts?
Yeah, so I hesitate to answer this question because I think I think that it's very complicated, and I think that there's a lot that we need to know. There's more information that we need to learn about how ISPs are using the information that they collect before we determine what practices should be completely off the table. I also hesitate to name certain practices that should be off the table at the risk of suggesting that other practices are necessarily okay when I'm just not sure because I haven't done a full analysis. That said, I think that there are going to be there are certain practices that we have seen that raise some serious concerns that I would be hard pressed to justify with any set of facts. And so one is maybe engaging in deep packet inspection for certain purposes. I mean, I recognize that there are certain reasons to look at packets of information, but engaging in deep packet inspection is something that raises very serious concerns. There's a lot of very sensitive information about communications that can be absorbed from looking at these specific packets, and I think that we need to look at that very carefully. I think that there might be certain types of information that, as I have mentioned, Wi-Fi routers have access to, and ISPs often force their customers to use their own Wi-Fi routers, and I think we need to look very carefully at that, particularly when customers might have shared files, shared folders on their home networks, and some of those devices might be able to see what's in those. I don't know whether or not that information is being collected. Maybe it's not, and I don't know how it's being used, but we ought to look carefully at it. And another is header injection. So we've seen with the Verizon permacookie and the related AT&T practice, those are very concerning practices when ISPs are injecting headers that then not only can be used for internal marketing purposes, but might be able to be used by any third party that a customer is communicating with to track customers across websites and over time, and that's very concerning. And then I don't know. I'm sure that I have more, but I'm not going to list them. All right. Thank you.
Catherine, did you want to speak to this?
I think one distinction I often found useful is distinction between my current self and privacy concerns pertaining to that and my future self, say me 10 years down the line. And the kind of data that concerns me the most is the data collected now, which can affect my future self in ways I can't possibly predict. And so one thing I would be interested in thinking more deeply about is the question of how long should we keep this data? Should my browsing today be stored and maybe used as part of my profile in 10 years' time? That seems to me a useful question. Another useful question, which also draws on this distinction between my future self and my current self, is how we deal with children's browsing in broadband. Because what strikes me, which is a little bit distinctive, is that in a household, everyone uses broadband, including children. The distinction between what I do now and my future self is even maybe more pronounced. how can we think about protecting children within the sort of framework of broadband context?
So thank you, everyone. I am going to close it out by saying, as the chairman mentioned, this is really the beginning of a conversation, and I think this panel has done a great job flagging enormous numbers of important issues for the FCC to consider as we look at these issues, and we invite further conversations with everybody at the table, in the room, on the web. For those of you who are in the room, I've been asked to tell you that we will start the next panel promptly at 1 o'clock. So panelists, please be back before then, and the rest of you, please be back by then. Thank you. And thank you. Please join me in thanking the panel.
Can everybody please have a seat? Okay, we're about to start our second panel. Just want to remind everybody watching online, if you have any questions, send them into livequestions@fcc.gov, livequestions@fcc.gov. If you have any questions here in the room, we have index cards. Just raise your hand and someone will come over and give you a card. All right, we're about to start. Thank you.
Great. Thanks very much, everybody, for coming back and coming back on time. That's fabulous. So we've heard, I should introduce ourselves. Matt Del Nero from Wireline Competition Bureau and my colleague Charles Mathias from the Wireless Bureau. Hopefully by our presence of the two bureaus, we illustrate we're thinking about both the fixed and the mobile ISP dimension here. We've heard so far about data flows in the ecosystem from Professor Blaze, followed by, I think it's fair to say, a spirited and full discussion about policy matters associated with the relationships between ISPs and their customers' personal information. So we're now going to turn to a more legally focused panel. The basic aim is to engage in a thoughtful discussion about what it means to apply Section 222 of the Communications Act to broadband internet access services. By way of recap, as most or all of you probably know, the Open Internet Order in February applied Section 222 of the Act to broadband internet access services, but forbore from applying the existing CP&I rules to broadband. In effect, among other things, the Commission said it was not persuaded that the current rules implementing Section 222 necessarily would be well suited to broadband internet access services. And so in part what we're looking at today is really what does it mean to apply 222. At the outset, let me say this is not to suggest that Section 222 of the Act should be viewed in a vacuum, and I'm sure today's discussion will at times situate 222 in a broader context. But the fact is that 222 of the Act has been a primary tool for the Commission in its privacy activities. And with that, I would like to turn it over to my colleague Charles to introduce our panel.
Thank you. And we're fortunate this afternoon to have a distinguished panel that will present a diversity of perspectives on the application of Section 222 to broadband internet access services, including those who represent leading public interest organizations, legal counsel to ISPs, and other innovative companies, and a leading scholar on privacy. Their bios are available in the room, so I'll simply introduce them by name and organization in alphabetical order. Harold Feld, who's Senior Vice President at Public Knowledge. Jim Halpert, who's Co-Chair Global Data Protection and the Privacy Security Practice at DLA Piper. Nancy Liven, who's Partner at Wilkinson Barker Nauer. Eric Stallman, Director, Open Internet Project and General Counsel for the Center for Democracy and Technology. And Peter Schweier, who's the Nancy J. and Lawrence P. Wang Professor, Scheller College of Business, Georgia Institute of Technology. So with that, turn it over to...
Yes, I think we'll each say 3 to 5 minutes, and Charles is really strict about that, so he's going to enforce that. And I also wanted to mention, thank Professor Schweier in particular. I know he has a very tight schedule to get a flight back to California, and we moved the schedule around a bit on him, so I apologize for that. he will need to leave at about 10 till 2, if that's right. So we will
save all the good stuff.
All that we can from you before then. With that, we'll turn it over to Harold.
So I warn everybody that to be quick, I am going to devolve into a lot of lawyer talk, so I encourage you to follow my colleague Jody Griffin, who will be translating all of the statutory sections on Twitter as I discuss this. First, it is important to understand the FCC statutory responsibility and our goal here. This is not about solving the privacy problem. This is not about regulating the Internet. This is not about, well, the universe is just an awful place for privacy, so who cares anymore? This is about implementing Congress's statutory directive with regard to communications platforms, which, while in the telecommunications context is under Section 222, is not limited to the concern over telecommunications. The cable privacy statute in 47 U.S.C. 551, the anti-interception statute in 47 U.S.C. 605. We have criminalized interception of communication under 18 U.S.C. 2511. We provide particular protection and strong warrant provisions for these forms of electronic communication where we do not do so for other forms of information on the Internet. We need to realize that society generally and Congress in particular has directed the FCC in a manner here that is narrow but deep to protect the privacy on the communications platforms itself, and there are important reasons why this is true. First and foremost, we need to understand that Congress and the American people have a strong expectation of privacy in communications. Chairman Wheeler referenced concerns going all the way back to the Federalist Society with regard to the critical nature of interception. My wife is a pharmacist. I asked her, so what would happen if you could not count on the privacy of the phone network to communicate with patients? How would HIPAA deal with that? And she'd say, that would probably be a HIPAA problem. We need to recognize that as our networks merge and blur together and we move everything onto the IP-based networks, that the rock-solid privacy that we have taken for granted in communications and for the phone network in particular, upon which all of these other specific privacy schemes are based, whether they are financial, health, or other, ride on the assumption that the network itself is neutral and privacy protected. Second, we need to understand the competitive aspect about this. I will refer to something called the Verizon customer retention case for the lawyers in the crowd, but I will just point to a couple of examples that raise particular concern. Comcast, for example, has required Netflix, or Netflix and Comcast have come to an agreement to allow for direct interconnection between subscribers trying to access networks competing video service with the video service that Comcast offers. Should Comcast be permitted to use the information that it can collect in that context to determine the viewing habits of its subscribers who are also Netflix customers so that it can better offer services to subscribers? That is a classic competition concern with regard to this, which at least in the telephone context, we answered, no, you shouldn't be able to do that. That is why it is customer proprietary network information. I also will note in reaction to some of the other issues that were raised in the last panel that and I see I'm coming near the end of my time, that we have found two things. One, the CP&I statute, Section 222, is technologically sophisticated and was designed to be so. Many of the things that people are afraid would not be possible for good network management, would not be possible for efficiency or public safety, are in fact explicitly made possible under the statute, and it is still considered to be a gold standard of privacy protection. The other thing I will point out is billions of dollars, trillions of dollars have been invested in internet infrastructure and in services such as VoIP without the need for an advertiser-based model. In point of fact, VoIP is now a standard form of communication, as everybody in the tech transition tells me, supplanting traditional PSTN use, and that was done after explicitly extending Section 222 privacy protections to VoIP. And despite that, we got a lot of investment in that. So the notion that we have to allow advertiser-supported information in order to encourage investment seems to me to be suspect. I'll hold my specific recommendations for your questions.
Hi, I'm Jim Halpert, and I counsel clients on compliance with many different privacy requirements across many different sectors. And if there's one thing that the United States privacy regime is criticized for, it's being overly specific and having weird status-based regulation that will apply in one area and then not having gaps in other areas. And I think one of the areas of greatest strength in the U.S. system has been the FTC's generally omnibus regulatory authority or enforcement authority with regard to privacy and security of personal information. There already are, as Harold mentioned, a bunch of laws that already apply to various IP-based content that's delivered to consumers or interception of communications. All those continue to apply today. Before the net neutrality order issued, the FTC was regulating privacy and security on broadband networks and had that authority. The only thing that's changed is the net neutrality order and classifying these services as common carrier services. The FTC has a gap there. But what makes the most sense is for the FCC to apply a similar set of criteria that the FTC applies. You've already heard from Chris Olson earlier today about how the two agencies work together, but this approach will avoid a whole lot of confusion, difficult rulemaking questions, perhaps challenges to the FCC's own authority if it is to apply a different sort of standard specifically to Internet access providers. But most importantly, it coincides with what consumer expectations really are. If you look at a device like this and you're a consumer, you are not going to expect one set of requirements that apply to the Internet access provider or the wireless provider that's giving you connectivity to the Internet and a different set applying to the operating system or the apps. What makes sense is to have one set of rules that fits consumer expectations. It's a much easier road for the FCC to travel here when it's carrying an awful lot of different rulemaking challenges in the wake of the net neutrality order, and I think ultimately it will both fit consumer expectations and be a lot more popular with legislators who are looking at passing data security legislation and threatening the jurisdiction of the FCC. So that's what I'm here to recommend, and delighted to have a discussion about specifics. I will note one thing from the first panel that is very important and that was completely missing from the first panel. The FTC held an entire day-long workshop on the question of whether there was comprehensive data collection by a particular set of actors on the Internet, and decided that there was not because it decided not to move forward in the wake of that proceeding. In particular, Laura was there among others. There were a bunch of people who said, no, ISPs pose a great threat to privacy, and I think the Commission was probably convinced by the fact that an AT&T or a Comcast or a Charter has an awful lot of value in their ongoing relationships with consumers. So the more sort of outrageous or difficult to understand activities that Laura noted are not ones that these carriers engage in or cable operators engage in. And I think we need to look at this issue not from a theoretical but from a more practical perspective and try to simplify rather than complicate the regulatory scheme here. Obviously, if there's sensitive information involved, the FTC would require additional protections for privacy and security, but I think that sliding scale approach makes the most sense. Thank you.
Thank you. Thanks for having me here today. I'm glad the Commission is hosting this workshop to discuss this very important issue of consumer privacy. You've heard a bit already about the number of laws that already govern privacy, consumer privacy online. I'm going to focus today, right now, on Section 222 in particular. Congress drafted Section 222 to achieve two purposes. The first had to do with the confidentiality of certain customer information called Customer Proprietary Network Information, or CP&I, and that information includes the type of service to which a telephone subscriber subscribes to, or call detail records of that subscriber, and so forth. It's information to which telephone companies alone had access to by virtue of providing telephone services to their customers, and Congress sought to protect the confidentiality of that category of customer information. The second thing Congress wanted to do was promote competition. It recognized that CP&I was a valuable marketing asset for telephone companies, and it sought to regulate it in a way to promote competition in the wake of the Bell divestiture. So why is this important? I raise it because Section 222 is different from the other privacy laws that protect broad categories of information, often called personal information or personally identifiable information. And that's, again, because Congress sought to protect this narrow category of customer information to which telephone companies had unique access. Therefore, I would caution the Commission in reflexively applying the four corners of Section 222 to broadband providers, and instead look to adopt a 21st century privacy regime that reflects the reality of the Internet economy and regulates the same data consistently across different regulatory regimes and platforms to ensure that consumers are protected while still having access to a broad array of services. Applying Section 222 to broadband providers is complicated. Unlike in the telephone context, where telephone companies have unique access to certain data that consumers generate, many entities in the Internet ecosystem, and we heard this earlier today, and I'm sure we'll hear more about it, many entities in the Internet ecosystem, app developers, operating systems, search engines, and so forth, all have access to the same consumer information. In fact, some of these entities may often have more comprehensive access to this information because they may interact with consumers across multiple different broadband connections. In addition, unlike in the phone services, telephone services context, data has a special purpose in the Internet ecosystem. It's the lifeblood of the digital economy that which depends on the free flow of data. Therefore, I would caution the FCC in defining CP&I under Section 222 too broadly, or imposing strict rules on broadband providers because it would have a very different effect in the Internet ecosystem than it does in the telephony context. And I'd also note that consumer expectations are different online than they are in the context of telephone services with respect to data that telephone customers generate. So in closing, I would urge the Commission to consider issuing an NOI in the first instance to further explore these issues and how applying Section 222 to broadband providers would affect consumers and business models in the Internet economy as a whole. And finally, I want to say one final thing about the Yourtel Terracom NAL, which was a broad and unexpected expansion of the Commission's jurisdiction and has created an uncertain environment for carriers. I would just urge the Commission to proceed cautiously in that area during this period of uncertainty as it determines how to proceed with Section 222. Thank you.
Great, thank you. On the Center for Democracy and Technology, we did argue for application of Section 222 to broadband in the context of the Open Internet proceeding. And I think we did so in part because the reclassification of broadband would leave a certain vacuum with regulation of privacy from broadband providers, but also because we think that Section 222 is a strong statute and a good model for privacy protections. And to sort of key off a disagreement, I think on the last panel and probably on this panel as well, we do believe that ISPs stand in a unique relationship to their customers compared to websites, whereas a person might visit dozens or hundreds of websites at any given time for discrete and limited purposes. Their relationship with their broadband providers is by comparison comprehensive and unavoidable. All of the traffic, everything they do will pass through the ISP's infrastructure. So we think that distinction is meaningful, but we don't mean this to suggest that you deal with privacy by promulgating good rules under Section 222 and then sort of walking away. We're receptive to the concern that you would have asymmetrical privacy regimes between broadband providers and other actors in the internet ecosystem, but we think that this is an opportunity to establish good rules that serve as a model and for baseline principles that would apply to other actors on the internet. So this is, we view this all as an opportunity. In terms of the actual text of Section 222 and the definitions of CP&I, I agree with Harold that it is a sophisticated statute. At the same time, its application to broadband isn't entirely self-evident on what constitutes the quantity, technical configuration, type, destination, and amount of use of a telecommunications service in the context of broadband isn't entirely clear, and I think that Professor Blaze earlier, he did a good job explaining that there's a distinction sometimes between metadata and the actual content of activity on the internet that is often very hard to determine, and I don't know if it's the best idea to try to determine that in the context of this proceeding. There is one sort of interesting rule of thumb that's been in some of the early orders applying Section 222, which is that CP&I is information that is both personal to the subscriber and also commercially valuable to the carrier. And I think that we should look at that standard and see if there's anything we can glean from that rule of thumb and trying to determine what is CP&I on the internet. And then also one thing that I think is useful to glean from the rules and the statute is that CP&I doesn't end, the determination that something is or is not CP&I does not end the discussion. Certain uses of CP&I, for example, in the administration of the network, can be done without the consent of the user. Certain times you can share that information with third parties, subject to only opt-out consent if doing so is necessary for the provision of the telecommunications service. So those types of uses I think we should permit and encourage, and it's really when you get into marketing that and unrelated uses of the information that I think a higher standard for notice and a higher standard for consent really is appropriate. So I'll just end by saying that I think that while Section 222 is unique to broadband, and there's a good reason for that it really is, I think this is an opportunity to pass some of the most significant privacy regulation in years, and I think it's a model not just for broadband providers, but for also the entire internet ecosystem. So that's it.
Yes. Hi, this is on? Okay, so first my apology for leaving early. I simply can't get to the right part of the West Coast today unless I leave early, so I'm going to leave early. If I'm not here for all the question part, I did write 14 single-space pages that you can refer to for at least some of the issues that I think about. So based on the questions that staff posed, I tried to highlight areas where my own experience as a privacy person for a lot of years could be helpful in my previous scholarship. And the organizing benefit of my remarks is, what is consumer benefit? Consumers want various things out of life. They want privacy, also want cybersecurity and a variety of other things, but that's my organizing principle. In the written remarks, there's three areas that I highlight. The first has to do with this question about how Section 222A, which has the term proprietary information, fits with Section 222C, which is the CP&I provision. The one thing that I think people haven't talked about as much there that I just mentioned in my remarks is that it's tricky from a compliance point of view, if you're trying to do compliance in a great big organization, to have multiple definitions of what's in scope or not in scope. And so I just urge, however the commission goes on this, to imagine you're the chief privacy officer responsibly trying to do good things inside your organization, and would you know how to build and manage it? And if you have lots of different definitions of what's in and out, that can be a tricky thing. Second, there's discussion in the paper about the intersection of privacy and competition law, and this occurs not just in last mile, but also for other markets, including online advertising. So I've written about this in testimony to the FTC years ago in terms of Google DoubleClick. And the thing here is to learn the facts of different markets, including these online advertising markets. Think through who logical competitors are for new entry and promoting competition. And I think if you think of privacy as a non-price aspect of competition, you get some insights that might be useful there. The third and longest part of my written remarks concerns various priority uses of information that I think should be permitted and thought about in this overall privacy and CP&I context.
I'm not saying this is the exclusive list of exceptions, and I'm not saying that there should be exceptions under a particular form of rule, but there are other important things in any governance of data regime and any privacy regime you care about. So the first one I discuss is anti-fraud. In this day and age for mobile phones, people hijack phones. They have fake SIM cards. They do account takeover. For broadband devices connected to the network, that will happen in the future. We should have anti-fraud that matches the risks to consumers of the more complicated ecosystem that we're living in. A second and somewhat related point is cybersecurity. The Chairman Wheeler was at RSA recently talking about how that's a huge priority for the FCC, and privacy is also. We should try to have both, and many, many times they work together. But there needs to be a thoughtful set of cybersecurity people talking to the privacy people as you develop a policy here, how to do the fact-finding. And I think consumers want their own networks at home, et cetera, to be secure, and that's a consumer benefit as well as broader public safety. A third thing that I mentioned in the discussion is something folks haven't talked as much about, which is how do we do research about network usage? I was very involved in HIPAA. And HIPAA, we needed to do medical privacy. We did not want to shut down medical research. There would have been some very upset people if we had closed down medical research in the United States, to put it mildly. And in HIPAA, there's a number of ways you can do research, such as going to an IRB, an institutional review board, with actually tailored questions under HIPAA for what it would take to have the right kind of controls around privacy, security, proper usage, but to be able to dig deeper into how the networks actually operate. I'm at Georgia Tech now. I teach privacy and cybersecurity and talk to researchers who face real obstacles to finding out how some of this stuff works. I think that could be usefully built into what's done here. The last item on the list, and it's related to how you do research under HIPAA, because de-identification is one of those ways, is there's a whole topic of de-identification and re-identification that's been a super hot debate in a lot of different privacy fora. Any privacy regime is going to have some things that are identified and some things that clearly aren't, and there's a huge battle going on about how to fill in the middle. I won't resolve that in the remaining 30 seconds, but I did write a little bit there and cited some papers. I think that if you simply say anything that is linkable under any scenario counts as privacy protected, you go so broad you lose a lot of other things. The FTC's done work on this, talking about what it would mean to be reasonably linkable. They do technical and administrative controls to get to that, and I think that's a useful thing to look at as we proceed. So the last point is to come back to a consumer's benefit from good research, from anti-fraud, from cybersecurity, from having the right level of things included and excluded, from having competition in markets, and that lodestone of consumer benefit, I think, disciplines people's thinking and is useful as you go forward. Thanks.
Great. Thank you, Professor Swire, and to all of our panelists. I think you've set an excellent foundation for the discussion. One thing that both Nancy and Eric, and I think others, touched on is really what is CP&I in the context of an ISP's use of data. The key part here is in 222C, for those of you following along with your own copies of the Communications Act, about customer proprietary network information, and it gets defined in 222H, information relating to quantity, technical configuration, type, destination, location, and amount of use of a telecom service, and made available to the carrier solely by virtue of the carrier-customer relationship. So how does one take that, and what do you think? I should note, in the telephone context, the Commission simply codified that definition, didn't necessarily interpret it. What's the panel's view on that? And I think Jim's I can see him ready to jump in. So.
I don't think this is an easy question, and I think it really does require extensive comment through an NOI and ultimately a rulemaking. You could just take the word location. Location could mean just the place where somebody receives service and pays their bill, or it could mean where a particular device is located. The original meaning was almost certainly just the device where one received service. There's a whole lot of back and forth and consideration just of that one term in the definition, and I don't think on this panel we're going to get to the bottom of this. At most, we can raise issues for multiple rounds of consideration.
I would like to just add a caution. As a lawyer who has worked with other lawyers, I know that there is no question that cannot be made more complicated and more difficult. As a consequence, it is wise to recall what the courts and the FCC have often said, which is you don't have to solve the entire problem at once. There are certain things that are fairly obvious that can be put in place right away. The statutory terms on their own, as well as the statutory goals, give the FCC sufficient guidance. To the extent that experience shows that these things need to be further interpreted or expanded, the Commission is capable of doing that. And while I am not nearly as heartbroken as some of my industry colleagues appear to be over the supposed exclusion of the Federal Trade Commission, I will echo one of their points, which is to the extent that a gap now exists other than pursuant to Section 222, it behooves the Commission to move as quickly as possible to fill that gap and to put in place at least some measure of protection, even if it's only the statutory terms, which would then be interpreted in case-by-case adjudication through complaint.
Thank you. Anyone else want to touch on that? You want to go to the next?
Well, I'll add a couple of things that are not within the definition. Yeah. The word personally identifiable information is used nowhere, or personal information, in the definition of CP&I. And it's very different than, this is a provision that was added to the Communications Act principally by Ed Markey, who over the previous 10, 12 years had authored several other privacy statutes that apply in the communications sector. And this is really talking about specific information that is obtained solely by virtue of the relationship, in this case, I guess, by the broadband internet access provider with the data subject. So it's not going to be the sort of general language that the general type of customer personal information that the Yortel decision, which Peter alluded to and mentioned was on pretty shaky ground, applies to. This is technical information that relates to the nature of the service that's received. So I think that in the end, one can put this into the statute, into a set of rules pretty quickly, but the actual scope of it and its utility as a general privacy protection term for broadband users is somewhat limited because the definition is so technically focused and so focused on individual items that relate really to the information that a telecom carrier was going to obtain from a customer. This is not an omnibus privacy statute, however much some of the privacy advocates here like it. It's pretty narrow.
Yes, it is indeed very narrow, and that is part of its virtue. There's a lot of fear-mongering that's been going on about its potential reach, particularly to edge providers and others who are not telecommunications service providers, and certainly the statute does not apply in those situations. Likewise, while there are questions with regard to information gathered using the telecommunications service and then shared with a non-telecommunications service owned by the same company, which would clearly fall within the CP&I statute, to the extent that companies, like say Comcast, which is involved in as a power company, or AT&T, which owns a security service, AT&T's security service is not subject to CP&I rules. However, AT&T's network should not be used to subsidize AT&T security service by providing information about when I, if I were an AT&T customer, call the complaints line of my existing security service, and then AT&T Wireless shared that information with AT&T Security to take advantage of that competitive opportunity. Those are cases where it seems to me you can apply what I characterized initially as your narrow but deep authority over the entities that are regulated to achieve the pro-competitive and pro-consumer interests of the statute.
Just Just quickly, I do want to say that I think that the fact that the CPI definition doesn't use personally identifiable information is actually a potential virtue of the definition, and that I think that other agencies have sort of struggled with how do you bring in concepts like IP addresses and cookies into the definition of the collected information that you should be concerned about, and I think that's a problem that you don't have when you're trying to determine what is and what is not CP&I.
The statute does, though, draw distinctions between individually identifiable and non-individually identifiable, and I wonder if anybody had any thoughts about whether that distinction continues to make sense in the context we're discussing.
I wrote a little bit about. So any regime that has a realm that is covered as private and individually identifiable has to have a line where something outside becomes no longer identifiable. If there's anything that counts as individually identifiable, you're going to have to define a boundary. And so you can't wish away, whether it's PII or some other term, you can't wish away that problem. And it's even more problematic because we've learned so much about how to re-identify people in various settings. And we can't get away from that either because those are just technical facts. So you're going to be stuck, if there's anything individually identifiable, doing a boundary and confronting this DID and re-ID problem. Sorry, there's not a way to avoid it, and you're going to probably have to get a bunch of technical people to help with some of that because it's the PhDs who do a lot of the work at the edges.
But Peter, as you mentioned earlier, the FTC has done some excellent work in its privacy staff report on when information is sufficiently de-identified. And there's no need to reinvent the wheel. There are contractual elements, administrative elements, and technical elements, and this, I think, is one of the most useful of many useful insights in the 2012 FTC Privacy Staff Report, and provides a good roadmap.
And was pushed and released when Ed Felton, who's a very well-known professor at Princeton, was the chief technology officer. So you have, gold quality technical people who had an input to that process.
I will merely point out that the FCC has teed up before it a petition for declaratory ruling that addresses many of these questions, particularly the nature of when information is identifiable or could be used to identify, as opposed to when it is simply obscured. It's been a year, getting on a year and a half, guys. And while I will not, necessitate filing an ex parte here, I will simply point out that, that is a splendid opportunity for the Commission to provide some guidance on this issue.
Thank you, Harold. That's great. Well, I was debating at what point to bring up 222A. But I think it already has come up a couple times in this discussion, and of course 222A was in part referred to in the Terracom Urtel decision that was referenced, and in there, many of you may know the facts, but just to quickly recap, there was a $10 million fine proposed for a company that took names, addresses, social security numbers, driver's license, and other proprietary information belonging to Lifeline customers and applicants, and made them available in a way that could easily be accessed, for example, with a search engine. And the Commission, in interpreting the scope of 222A, said the overarching principle is we should interpret the term proprietary information in the commonly understood sense of information that should not be exposed widely to the public. So was hoping we could discuss a little bit, since we've talked about 222C, we'll come back to C on CP&I, but just talk about this 222A issue, since it did come up in a number of the introductory remarks. And Nancy's, yes.
Can I address
Please.
that? So I'm glad you brought that up, and I just want to refer...
I think you brought it up first.
Well, maybe I did.
Sorry.
I just want to refer...
Yes.
I just want to refer to the statute itself. So if you look at Section 222, and Section 222A states the general requirement that carriers protect the confidentiality of not only customers' proprietary information, but also that of other carriers and of equipment manufacturers as well. Section 222C defines what that means for customers, and it defines customer proprietary network information, which Section 222H defines in a more granular way to include a finite set of information to which telephone companies have access to by virtue of providing services to their customers. And as we said, that includes the technical configuration, quantity, type, and so forth. So Section 222A is a general statement of overall purpose of that particular section. And it would not make sense to read Section 222 to cover customer information beyond CP&I, because all of the other subsections of Section 222 that address this issue with respect to customers refer to CP&I. So exceptions to disclosure, the prohibitions on disclosure of customer proprietary information only refer to the disclosure of CP&I. They don't refer to the disclosure of any broader category of customer information. So it would simply make no sense if 222 captured a universe of information with respect to customers beyond CP&I.
I would point out, however, that this structure of having a general statement of duty applicable to all providers, followed by more specific and granular requirements which are meant to provide a floor rather than a ceiling or a safe harbor from the general duty, is common in the Communications Act. In particular, I would refer you to Section 251, where 251A imposes a general obligation for interconnection, and then the remaining sections of Section 251 impose particular obligations with regard to particular carriers. Similarly, Section 628B refers to the general obligation of cable operators to avoid engaging in unfair and anti-competitive means of competition, and Section 628C has then very specific regulations that the Commission was required to adopt with regard to particular entities. So while there is nothing that prohibits reading the statute in the way Ms. Libben suggested, I would say that it is in fact consistent with the general structure of the Communications Act to read it in the broader fashion with which the Commission has more recently interpreted it.
But what's confusing is it would be an absurdity to say that the other categories of information can never be disclosed, which if you were to read the 251 duty to protect confidentiality, it makes total sense with regard to competitor information or equipment manufacturer information. But if it means that for example, for fraud prevention purposes, the social security number of a customer who's applying for service cannot be used to check to make sure that the customer really is who they say they are, for example, that disclosure can't be made, it just wouldn't make the statute wouldn't make practical sense. And because those exceptions don't apply, I think that Ms. Libben's point is a pretty strong one. Moreover, it makes sense to the extent that the Commission's relying on sort of general catch-all authority under 201B or some interpretation of 222A that exceeds what the category of CP&I really is. It makes sense that it act consistently with the FTC, not apply a different set of standards or respond with radically different sort of penalties for a violation. Otherwise, the overall statute becomes unpredictable and somewhat difficult to interpret from a compliance perspective.
Thank you. I'm aware we're going to lose Professor Swire in a few minutes, and I think you had some thoughts on this, so just wanted to be sure we got your views.
Well, first a disclaimer, which is there's people who have studied the Communications Act here a lot more than I have. I can't name nearly that many sections from heart. And I did. When staff asked me my views on this, I said I didn't know I needed to go read the statute. I went and read the statute, 222A, and I have a paragraph explaining in a sort of just a law professor's taught legislation kind of way why I think it's fair to say it seemed like a stretch to do it. Harold has given some arguments back the other way, but in my statement I give some reasons why just based on the grammar, and if you list some things, you exclude some others, those kinds of things, it looks like a stretch. And the other point I made about this is one I made briefly in my opening statement, which is whatever the FCC ends up doing here, it should be something a good faith company can figure out how to comply with. And I urge you to provide some set of ways to do that, and if the scope of what's being required is very vague, then in good faith companies really struggle. I've worked a lot with chief privacy officers. They really struggle with how to do that. So having two different standards that apply, and sometimes it's one, sometimes it's the other, sometimes it's both, is the kind of thing that can make it hard for a good faith organization to comply with the structure.
Okay, and we did get, and then I'm going to go back to Harold, but we did get because I know Harold has a point, but we got a question for you specifically related to this that said, given the FTC's common carrier exemption, how would ISPs be held responsible if they suffer a breach of something that's not CP&I, or is determined not to be CP&I? Let's say if it's a Social Security number determined not to be CP&I. How would the ISP be held liable?
I don't know enough about how state laws apply or don't. There's a 47 or whatever state breach laws. Are they all preempted? I just don't know the answer to that.
No, they wouldn't be in this context.
Well, I think there's also an argument that I think one could make that in that case, the ISP might not be performing one of its functions as a carrier, and therefore the FTC would have jurisdiction. It would not be precluded under the common carrier exemption from exercising authority in the case of a data breach.
Okay, thanks.
But the state laws have had a huge effect on lots and lots of companies that were not under federal legislation. And they would not feel, most companies would not feel themselves unregulated or free to breach when they're facing the 47 state laws.
The average cost of a notifiable data breach is between $60 and $200 per record that was breached. So there's a significant sanction, effectively, as well as a PR cost associated with notifying. The $200 figures from the Poneman Institute, and they look at the PR consequences, the damage to brand, as well as out-of-pocket expenses.
Okay. Harold, was there a point that you didn't get to make?
Just one point on a theme that emerges constantly, which is and I mean this with all due respect to the Federal Trade Commission, but the supposed superiority of the Federal Trade Commission in all things privacy, despite the utter absence of a statute actually directing the FTC to address privacy, and the supposed inferiority of the Commission, which has expressly regulated privacy pursuant to privacy statutes for, what is it now, starting with the 1984 Cable Act, 30 years now. I think that it is telling that every single business that is asked and every single industry representative that is asked wants to flee to the Federal Trade Commission with the grounds that this is conveniently ignoring that these entities are already regulated pursuant to this agency here, for their video services under the cable statute, and for their voice services, including IP-based voice services, for their voice. Furthermore, I just got to point out there are a lot of real differences in the businesses that we're talking about that are critically important. Nobody calls 911 through Facebook. Google does not have to pass its search results through Yahoo to reach a customer. These are differences that matter. It is why the FCC, as the particular specialized agency delegated by Congress explicitly to address privacy in this context, is particularly suited to make that judgment, and should, while the FTC is, of course, informative, and I agree with many of the suggestions that we don't want things to get too confusing and make it impossible to comply, but the notion that the Federal Trade Commission in 60-odd enforcement cases, none of which have involved a broadband provider until recently, is the end-all and be-all of all privacy knowledge, seems to me entirely too convenient for those who advocate it.
I think that's a bit of a straw man, though. The question isn't whether the FCC has enforcement authority. It's whether in bringing enforcement actions, it should act consistently or inconsistently with the pattern of FTC guidance which is developed and enforcement practices over the past 15 years. It is undeniable that the FTC has more resources to devote to privacy and has spent more time articulating a privacy framework. The 1984 Cable Act has not resulted in rules or extensive regulations, so the 1984 figure is simply not accurate, and CP&I is, while an important set of privacy protections, a pretty narrow and specific one. And when one looks at Yourtel and some of the other types of information that are involved, it makes sense that the Commission, while yes exercising enforcement authority, refer to similar sorts of standards that the FTC has articulated over 15 years.
With respect, the critical element is not enforcement authority, but rulemaking authority, precisely designed to provide clarity and certainty not only to the broadband providers themselves, but to their competitors and to consumers. And in that area, I would suggest that the FCC has far greater experience both in developing rules and in managing them and enforcing them.
But not privacy and security rules.
We're aware we're going to lose Professor Swire in a couple minutes, so we have
I get my
a
last
question
shot.
we'd like
Go ahead.
to start with him. Yeah.
It's related, but takes it back to what the Commission has been doing in this area, and in particular, whether there are any lessons that we can learn in the voice context, and particularly with respect to opting out and customer approval for disclosures. Are there things that you think are useful going forward, or?
Right. Well, so there's an anti-fraud provision where there's no opt-out, and that's partly because if Eric is the fraudster, he'll opt out, and then I can't catch him. Right? This is well known. No, seriously. Same for cybersecurity. If I'm a bad guy hacker coming into the broadband network, I want to opt out of the cybersecurity oversight, so you can't figure out that I'm the master hacker. So there's certain kinds of things like that where you just don't want to have an opt-out. I suggested in research you can look at the HIPAA, Institutional Review Board ethical process as a way to put a lot of protections around research while still achieving some research that brings a lot of benefits, not just to my faculty colleagues at Georgia Tech, but to the nation at large.
So, okay. Just keying off that, I want to agree that I think it's important that whatever rules do emerge, that they don't discourage good faith security research. I mean, that's been an issue that's come up in a number of contexts, and people have struggled with provisions in the Digital Millennium Copyright Act, the statutes amended by the Electronic Communications Privacy Act, and we don't want to add to that problem by creating another potential obstacle to security research. In general, on the question of opt-in and opt-out, I just want to repeat that I think there is some useful guidance in some earlier applications of the rules. I mean, definitely, if it's a matter of a provider wanting to use information to figure out how to pull requested content from the content delivery network cache that's closest to the user, I think we want to allow that. That takes load off the backbone. It makes the user experience better, and so we don't want to prevent that. At the same time, use sort of more or less service-related uses of CP&I are ones where we do want, I think, opt-in consent.
I just want to say thank you for the opportunity to participate, and good luck to everybody on this.
Great. Thanks, and have a safe flight. Did anyone else want to talk to that? I mean, it's a big question, right, of opt-in, opt-out under the way the statute in 222C uses the term approval, right? You can't do certain things. There's some enumerated exceptions, and then you can't do certain things unless you have the customer's approval. And then the Commission has taken, originally it was mostly opt-in. There was a court decision around that. The Commission came back, did kind of more of a opt-in in some cases, opt-out in others. What's the right balance as you look to applying the approval requirement in ISP for ISPs?
Well, can I jump in? You mentioned the court decision, and I just want to mention something that the Commission has done in its proceedings, both in the wake of the U.S. West 10th Circuit decision and also later in response to concerns about pretexting in proceedings where the Commission has considered modifications to the CP&I rules and the opt-in, opt-out regime. Among other things, it has always It's done a good job of looking to the realities of the marketplace and consumer expectations, and I would just suggest that's a good approach to take here as well, and urge the Commission to do that as it moves forward in deciding how to proceed with Section 222, because I think that those factors, along with the other aspects of Section 222 that are difficult to squarely apply in the broadband context, those other factors, I think, weigh in favor of taking a very different approach in the Internet ecosystem because of the way in which data is used and is necessary there in the way that it is not in the context of telephone services.
Well, 2 points. One is, it is precisely to preserve the existing Internet ecosystem that the Commission must be most wary with regard to ISPs who sit in a very different position from any other company, intruding themselves into it and behaving rather in the manner of an invasive species in this regard. I think that the notion that has been advanced that this information is all out there anyway, that you can always access it, and that therefore we should not trouble ourselves about what ISPs may add to it, strikes me as the worst marketing slogan that any telephone company or cable company could come up with when selling this to third-party advertisers. Get the stuff from us that you can get from anyone else, even better, does not strike me as their real intent, or they would not be trying to enter into this market. And to the contrary, as we saw with the Verizon Super Cookie, which not only behaved in a manner which prevented consumers from protecting themselves when following best practices applicable to anybody else, but which also broke security systems and broke accepted encryption. That there is a tremendous opportunity for ISPs behaving in the manner as if they were edge companies to do untold damage to the Internet ecosystem for which people have such delicate sensibilities. The other aspect I will just make very quickly is many of these questions are addressed already under the existing CP&I regime. It was not so long ago during the implementation of the 1996 Act that the mysteries of network routing and how the phone system was going to work in a new competitive environment was equally complex and equally difficult to fathom going forward. And yet we managed to find a way to do that consistent with the CP&I rules. I would suggest that, particularly given that it is the Federal Communication Commission that is expert in these networking matters, that the FCC is uniquely positioned to ensure that we do not create barriers to good research, to important advances in network configuration, while simultaneously protecting both consumers and competition.
So can I just respond to part of that? So a number of different players in the ecosystem offer different types of ad identifiers, and some carriers, you mentioned Verizon, offer an opt-out for the use of an ad identifier. Other players in the ecosystem have a different approach, but that's not unusual. Operating systems use the same technique to provide ad-supported content to users. So I think we could debate about the merits of an advertising ecosystem, but it's there. And I think you can address some of these issues by transparency and consumer choice, which is what's being done.
Great. Thanks, Nancy.
Sorry.
Oh, yeah, please.
Just one quick addition to that, though, is I think that one thing that the Commission has said in the past is part of this question turns on whether this is information that the customer would infer from the relationship with the carrier that the information was being collected or shared, and I think it's hard to make that inference when you're talking about advertising. Yeah.
Okay, thank you, and I appreciate both Harold and Nancy, bringing out those issues. Definitely not looking to discuss any one particular carrier here. Just trying to get to the legal question of how 222 would apply to ISPs generally. So,
to that point, there are a lot of terms in the exceptions, both statutory and rule-based exceptions in Section 222 that really don't fit a broadband environment. They speak about things like telephone, toll service, directory information, and this is not all that straightforward, and it's something that I think that does require really pretty careful consideration in rulemaking, because this is a POTS statute. If you really look at the CP&I statute and the sort of terms that are used, it refers to telecommunications, but that the exceptions, some of the whole framework in terms of how it approaches service is really quite different than the world of double or triple play services that go far beyond telecom services, and whether this sort of framework should just be mechanically applied in a broadband setting is certainly open to considerable debate. So while I hear Harold's desire for rules and hear that the FTC has been doing this with regard to telephone service, as the broadband order itself, open internet order itself noted, this is a pretty complicated task with a lot of implications depending on how it shakes out.
Okay. I would say maybe there's just before you go into the next question, because I think this, we've heard a tension come up, I think, quite a bit, which is on the one hand, there is a desire for certainty, and that's certainly understandable. On the other hand, I'm hearing concern about applying, prescriptive aspects of the statute. So how do you resolve that tension? How do you provide some kind of certainty and guidance to industry while at the same time providing, some flexibility so the regime adapts with privacy challenges facing consumers?
Well, I mean, just to take one example, and the distinction between sort of CP&I and aggregate information. One thing that you don't want to see in rules is something that's overly prescriptive in terms of a technological mandate over you. You do these certain things, and suddenly this counts as being de-identified information. But at the same time, you want to provide some sort of standards that encourage people to continue to improve practices for de-identification of information. So, I mean, I agree with Harold that the FCC is good at rulemaking, and rules provide clarity to everyone in the internet ecosystem. And I think there's a way that you can do that by while still allowing flexibility, by simply being careful to avoid things that become technological mandates.
Well, I'll give you an example. The FTC issued, under the Gramm-Leach-Bliley Act, worked with federal functional financial regulators to issue a process-based set of security processes that has become basically the gold standard and the approach across different agencies. HIPAA is different. High-tech, that regime is much more specific. But by being more process-oriented and less not being technologically specific on security, one can come up with a frame, and it wouldn't be hard to take the Gramm-Leach-Bliley Act safeguards rules and replace what might otherwise be pretty unclear enforcement actions under Section 222A, and probably come up with something that would stand the test of time better than the Commission's current security rules that were adopted after the pretexting issues that drove Congress to amend Section 222. Generally, on security, hackers love checklists. They love to work around them. You can look at the failure of the PCI data security standard versions 1.0 and 2.0 to protect against breaches of payment card data to provide a pretty good example that process-based security approaches work better. With regard to privacy, it is generally speaking, I tend to think that sliding scales that are more flexible tend to work better if you look at how the FTC has granted without rules in many settings, but with guidance like the FTC Privacy Staff Report, which is an excellent piece of work. One can come up with pretty good guidance, hold workshops like this, and provide considerable clarity to the regulated industries about what crosses the line and what's okay. And I'm not saying that there's no place for rules ever, but if you want to keep up with a rapidly changing landscape, the sort of approach that the FTC has pursued here has been, I think, very successful in keeping up and continuing to apply pressure on companies to do the right thing.
I would just echo what Jim said. I mean, the taking a technology-neutral approach that's flexible and can respond to rapid changes in technology in the Internet ecosystem, I think, is important. And finding that balance between providing enough guidance but also being nimble enough to respond to those changes, not only not only technological changes, but in different business models as well. And in the Internet economy, I think, is important as more convergence takes place.
Mm-hmm. Now, again, I'm going to start with, it's important to recognize that what this agency is charged with in its own narrow little way is not with the burden of fostering the entire Internet ecology or Internet economy, but specifically with the underlying infrastructure on which all these things ride, to wit, the carriers. Obviously, I agree with everybody else in the non-helpful. It ought to be technology neutral and adaptable and all that good stuff. I would say that the specific recommendations that are important is privacy is security and security is privacy, and people overlook that. The more you structure, and while I don't want to pick on a particular carrier, I do have to come back to the Verizon super cookie example precisely because it broke encryption in order to facilitate the gathering of this information and exposed the information to third parties in ways that Verizon itself did not anticipate, thus further compromising the security of users as well as their privacy. The more a system is structured to gather information and report that information back to third parties and to share that information seamlessly with third parties, the more vulnerable it becomes. And in balancing security and privacy, we cannot treat these two things as separate. To the contrary, we need to be very cognizant of the fact that an unregulated privacy environment is an invitation to cyber hacking and to inciting security breaches.
But there was no unregulated privacy infrastructure. As I understand it, the passing of this identifier was not significantly different than what other players in the advertising world did in mobile advertising at the time. And it makes a great soundbite at a workshop like this to talk about this and say, breaking security, jeopardizing the security of everybody and all trust in the Internet infrastructure. But in point of fact, there are a lot of ad identifiers that are passed from mobile devices and computers, and it's actually an example of lack of technology neutrality to focus myopically on what a particular carrier does without taking into account the whole infrastructure. And this is exactly why the FTC and the FCC should partner together and act together in a broad-based way to protect consumer expectations, protect privacy and security, and not pursue a go to the max, focus specifically on broadband Internet access providers and adopt the broadest possible rules. In the end, that will not protect privacy, except with regard to one player in a much more complex environment. Furthermore, it creates disincentives for companies that we want to encourage competition in broadband. It creates disincentives for players who may have advertising-based models from deciding to get into this environment and do the sort of heavy investment that's required to launch a broadband internet access service in different parts of the country. And we have to be mindful of that, too. One can regulate and feel great about issuing rules. We heard the example in the first panel about what the bizarre effect of the EU opt-in rule for uses of consumer data for advertising. We may have some unintended consequences and create actually a barrier to competition if the regulatory regime is too inflexible and too much out of line with the way that other players who could get into this market are currently regulated. We want them into this market, and that's why having a uniform approach that's not status-based, but it really focuses on the particular type of data and how it's being used, makes the most sense ultimately.
Okay. With that, why don't we go to a different? I think we were talking about the tensions there between bright line, essentially, and more flexible standards, and so a lot of good information there. And I hope one thing that did come out clear this morning with Lisa and Chris is we are working very closely with the FTC.
Okay. So another area which is found not to be contentious is location information. Section 222F requires that there be express consent to use call location information concerning the use of a commercial mobile service or an IP-enabled voice service, except in with certain exceptions, including contacting a PSAP. So, how should we think about 222F in the context of our conversation today?
So, 222F talks about call location information. But I would note that 222C, or 222H rather, which lists the definition of CP&I, I think talks just about location generally. Mm-hmm. So of course consumers have a privacy interest in their location information. I think it's unclear, however, what kind of location information ultimately we're going to be talking about in the context of a broadband provider, and that's certainly something for the Commission to look at and do some research into. There are many different kinds. I think we heard I think it was on the first panel, network location, device location. There could be general location information associated with an IP address that might indicate a general geographic area where someone's located. These different types of location information are on a spectrum of sensitivity, and I think it depends on the type of location information you're talking about. But certainly consumers do have a privacy interest in that.
I think in our view, the location information is inherently sensitive. I mean, it is, going back to earlier orders, they talked about quintessential CP&I as being the who, where, and when of a call, and definitely the where and when is location information. I think that the 2011 report that the FCC did on location-based security, that actually did have some helpful, I think, suggestions of ways to think about this information. Things like ensuring that information isn't misused or mishandled, and ensuring that the customers know that there's some transparency and the communication of how that information is being handled by the carrier, and then ensuring a degree of consumer control and choice and how that's being used is important. And that report recognized that there will be issues, the tension between granularity of location-based information and simplicity in disclosing and allowing certain uses of it. Those have to be worked out in rules, but definitely, in our view, we view that information as sensitive.
I would suggest, one, that the Carrier IQ declaratory ruling provides useful guidance here, that where an application or technological function providing location information is installed by the carrier by virtue of the carrier subscriber relationship, that it should fall under CP&I, and as the Commission emphasized there, that does not mean that you can't, through opt-in, enable it to talk to all of your applications and or to the carrier itself for purposes beyond those provided for in the statute. That's why opt-in is a valuable tool. I also would just point out we had a related discussion around this in the enhanced geolocation for 911 proceeding, where the Commission has adopted for future enhanced 911 geolocation a standard which will potentially rely on third-party beaconing and essentially requiring that the mobile device be able to provide very specific geographic location. And we raised, and happily the Commission was responsive to, the concern that while that's clearly critical for emergency response, especially because it potentially makes the information available to these third parties providing the location beacons, that it raises a number of concerns as well. And so I would ask the Commission to be guided by the debate and working groups in those proceedings, and to consider very carefully how, given the intermixed nature of these services, the Commission has to be wary that something that's put in for one purpose, even a very laudable purpose, is not subject to abuse in a related line of business.
Okay. Yeah, no, thank you, Harold, and thank you for bringing up the 2013 declaratory ruling. That was the most recent non-enforcement Commission-level action on under 222, and it was a declaratory ruling about security of information on the phone. It was done under Acting Chairwoman Clyburn, and a number of people in the room, including Jennifer Tatel and Doug Klein over there, worked very closely on it. So, definitely, those interested in this subject, that's a good reference. Put in a plug for reading that. Great. I think we're just about out of time, and we haven't gotten any more questions in from the audience. I think that may prove that a bunch of lawyers talking about the Communications Act may not hold as much sway as some online video, but we want to thank you very much, particularly to our panel. I think you've set a terrific stage for, again, as was said earlier, this is the start of a conversation, and you really helped bring out a lot of the big issues here. So thank you all.
Thank you.